I have that it is 10 a.m. So let's call the regular commission meeting to order. The first thing on the agenda is review and approval of the commission meeting minutes for September 21st, 2017 and October 5th, 2017. Do I have a motion?
We approve minutes.
Sorry, hang on, let me turn them on. Okay. All right, do I have a second?
Second.
Okay, all in favor? Aye. All right, the motion passes. All right, the next thing on the agenda is the proposed quarterly schedule of the meetings for 2018. It appears that we need to go ahead and get those scheduled. We do one in each quarter. It would be my preference to, let's see, trying to read the calendar that we have in our binder here.
They're squared in red.
Okay, so Nancy, they're squared in red and some are highlighted and some are not highlighted. In blue and some are highlighted. Are the red ones federal holidays? Is that why they're?
Yeah, but the square, the outline square in red is the one scheduled
Red
in March,
square.
June.
Okay.
December.
Red boxes.
The red box is us, okay. All right. Okay, so it appears then that, make sure I have these correct, March 22nd,
Yep,
June 21st,
yes,
September 20th,
yes,
and December 12th.
yes.
Okay, does anybody have any issues with those dates? Anyone? Okay, hearing none then, do I hear a motion for the quarterly commission meeting dates for 2018 to be March 22nd, June 21st, September 20th, and December 12th?
So moved.
Okay, I have a motion. Do I have a second?
Second.
All right, I have a second. All in favor? Aye. Okay, fantastic. All right, the fourth thing we now have on the agenda is the matter of 2012-0010 PC in the matter of Irby Allen Metters. It's a review. Tell ya, coffee hasn't kicked in for my mouth today. Review of OSA's initial decision. So, Ms. Wetzel, is this your matter?
It is.
Okay, so before we go any further, I needed a little direction from Mr. Ritter on what we are needing to do other than just review this decision. Are we needing to vote on it?
Okay, so you do not need to vote. In fact, you should not vote today on this decision. That is because they have 30 days in which to challenge the decision here, which they have not done at this point. Maybe preempting Ms. Wetzel on this, but I will tell you that we put it on the agenda at my request to make sure that you were notified that we did receive such a decision. In staff's view, it's a fine decision, and it can be affirmed by operation of law by no action of the commission. However, should they appeal or challenge the decision to you, then we will need to hold a special meeting to consider the decision.
Okay, all right. So is Mr. Metters here or anyone representing Mr. Metters present? No. Okay. All right. Then Ms. Wetzel, then you will go forward, please.
As Mr. Ritter stated, this is simply just a notification that we received a final, initial decision rather, from the Office of State Administrative Hearings. On March 24th of 2016, this matter came before the commission, and at that meeting, y'all, the commission found a reasonable grounds to believe that violations had occurred. Those violations were that Mr. Metters failed to pay lobbyist registration fees. After 30 days, the matter was forwarded to Mr. Fuller, to the Attorney General's office for handling. Mr. Fuller filed a statement of matters asserted and initiated the case for us at OSA. And we had a hearing in October. It lasted maybe a couple hours. We had several witnesses from the commission, and Mr. Fuller successfully argued on our behalf, and the initial decision from the OSA judge that the commission's proposed action was affirmed. The finding that 2 violations did occur were affirmed, and she affirmed the civil penalty that was proposed of $620.
Okay, so this time, then we have nothing further to do on this. Okay? All right, fantastic. Thank you, Ms. Wetzel. All right, now we're moving to item number 5, which is 2017-0005 in the matter of Stacy Culverman. It is consideration of a motion to dismiss. My understanding of reviewing the minutes is that this matter was tabled in September so that Mr. King could be here. So, is Mr. King here?
Yes, ma'am. Madam Chair, Mr. King was here on the previous occasion. My understanding, correct me if I'm wrong, that it was tabled in order to allow me an opportunity to respond in writing.
That's
Which I
correct.
did, yes.
That's correct. My apologies. Yes, that is correct. That's
And
correct.
I did respond in writing.
Yes. Okay. All right. Then this is,
Do you want me to table it?
please. This is Mr. Lane's
It is.
matter.
Yes, ma'am.
Okay.
Mr. King is present.
Wonderful.
You can be seated. That's fine.
And I believe Ms. Culverman is here, correct?
She is, along with her
Okay.
attorney, Ms. Kimberly Worth.
That's right. Okay. Thank you.
Okay. Good morning, Commissioners. As the Chair has gone over, this is a continuation of a motion to dismiss hearing which began in your last September meeting. The, of course, key people are, of course, Ms. Calverman, who is the respondent, Mr. King, who is the third-party complainant. Ms. Calverman is represented by Ms. Kimberly Worth, and Mr. King is represented by Mr. Dwight Thomas. In the hopes of keeping things relatively simple and provide y'all by way of a refresher to some key people and relevant dates, Ms. Calverman, as you know, serves as the ethics officer for the DeKalb County Board of Ethics. The DeKalb County Board of Ethics is a county authority that was reconstituted in 2016 by House Bill 597, which we refer to as the DeKalb County Ethics Code. And the DeKalb County Ethics Board is charged with the enforcement of that code. Mr. King is the third-party complainant, and he is the one who filed the instant complaint that is before y'all. That he filed that back in March of 2017. On October 20th, 2016 and November 22nd, 2016, the DeKalb County Board of Ethics instructed Ms. Calverman to go ahead and draft Senate Bill 273, or at least help in its creation, and then to promote that bill at the 2017 legislative session of the General Assembly. That promotion, I shall call it, began March 6th and lasted through March 13th. And the procedural history is that the complaint was filed on March 28th. On April 17th, we received the initial response by Ms. Calverman. On July 9th, we received a supplemental response from Ms. Calverman filed by her attorney. On August 30th, the commission filed its motion to dismiss, which is currently before you now. On September 21, we began the hearing that's continuing today. On November 15th, Mr. King filed his response, and on December 8th, respectively, the commission and Ms. Calverman filed their briefs in support of the motion to dismiss. There are 3 issues that y'all have to decide today. The first one is, does Mr. King have standing to file responsive pleadings in this case? Or simply put, does he lack standing? The second question is, did House Bill 597, the 2015 DeKalb Ethics Code, does it supersede and or amend the Campaign Finance Act in any way? And then the third question you have to answer is respondent entitled to claim an exemption under our lobbying code pursuant to Georgia Code 21571 I-6? or 21-571 I-4. The I-6 subsection is the exemption that applies to public officials and public officers, whether they be elected or appointed. And then I-4 is for an attorney representing their client in their official capacity as an attorney.
Before you go any further,
Yes,
Mr. Lane, if we decide that Mr. King does not have standing, then we do not need to get to 2 or 3, correct?
You would be able to skip number 2 and you'd be able to go directly to number 3. Mr. King is the only one who has advanced the argument that House Bill 597 has superseded our act. Both the staff as well as Ms. Calverman have maintained that the act is controlled.
Okay.
As to standing, the commission would object to Mr. King's standing because he's not a party to this case. As the commission knows, yes, sir.
We have a discrepancy between what's on right in front of us and what's.
There you go.
There you
Thanks, sir.
go. Get a crick in the neck, look no other way.
I do apologize, sir. As the commission knows, our civil procedure is controlled by the Administrative Procedures Act. And just like the Civil Procedure Act, under the APA, under 50-13-14, the third party may only intervene into a case if they can show one of 2 things. That a statute confers an unconditional right to intervene in a case, or the statute confers a conditional right to intervene into the adjudication of, and they can show that the existing party's rights will not be unduly delayed or prejudiced by intervening into the suit. In this case, Commissioners, I have to draw your attention to the term complainant doesn't appear anywhere in the Campaign Finance Act. It's a term of art we use to define who's filing a third-party complaint. There is no standing that is granted to a complainant at all in our Campaign Finance Act. The only time you're going to see the term complainant is in the Commission's consolidated rules, and it appears in Rule 189-2-.03, subsection 3. And all it references, aside from saying that the complainant is the person who files the third-party complaint, it states that the Commission staff, and that being the Commission as well, can ignore any pleadings or filings filed by the respondent and the complainant after 30 days from the date of filing of the complaint. That's the extent of our discussion of what a complainant is and what your standing is. Now, as I'm sure the Commission is aware, the Georgia Supreme Court has repeatedly held that in order to challenge a statute or an administrative action taken pursuant to any statute, the complainant must normally show that he has an interest or rights which are or will be affected by the statute of the action. And that's Atlanta Taxi Cab Owners Association versus the City of Atlanta, and they were being cited by Preservation Alliance of Savannah, Norfolk Southern. It's a 2006 case stemming from a 1991 case. It's still good law. They're both relevant. And in this case, Commissioners, Mr. King's not timely motioned to intervene at all. He didn't motion to intervene prior to the motion hearing in September, and he's yet to this day to ask to intervene, either by conditional intervention or by right. Now, the one issue I would draw your attention to is that the only time that a complainant would have limited standing in our cases is if the respondent is seeking the award of attorney's fees pursuant to 21-5-6, subsection 23. That code section provides the Commission the authority to assess attorney fees against the complainant for the filing of a frivolous action. In this case, Ms. Calverman, much to her credit, has not asked for the imposition of attorney's fees. So there is absolutely nothing that can happen to the complainant in this case. Even if the Commission were to find the complaint frivolous, attorney fees have not been asked. It's not under consideration, thus there is no standing. So for those reasons, I respectfully request that the Commission find that Mr. King lacks standing, that there is no need to further consider his responsive pleadings and the arguments that he raises, and that we would be able to move forward on the Commission's motion to dismiss and the argument under the Act, which is controlled. And procedurally, I don't know if you prefer for me to continue to address the other issues, or if you'd like to address standing now.
Do any of the Commissioners have a preference?
I'm going to be really quick. I promise I won't belabor it.
I think we go ahead and move forward
Okay.
with your presentation, Mr. Lane, and then we'll go from there.
Okay. With respect, did House Bill 597 supersede the Campaign Finance Act? It's a resounding no. The Georgia Constitution, more specifically Article 3, Section 6, Paragraph 4, holds that laws of a general nature shall have uniform operation throughout the state, and no local or special law shall be enacted in any case for which provision has been made by existing general law, except that the General Assembly can authorize local government agent or governing authorities to pass laws that don't conflict with the general statutes. I'd submit to the Commission that the Campaign Finance Act is a general legislation that applies uniformly throughout the state. Under the terms of our lobbying code, it regulates every person wishing to engage in lobbying in all 159 counties, and it's applied uniformly. No one gets an exemption, no one gets special treatment whether they live in Fulton County or Savannah. It's exactly the same everywhere. The Supreme Court has repeatedly upheld the constitutional provisions, and you can see cases going all the way back to 1942 and as recently as 2017. It seems that City of Atlanta versus Hudgens, 193 Georgia 618 is kind of a seminal case. Everyone cites back to it, showing that a special local enabling legislation cannot supersede general legislation. And that's what you have in this case. The 2015 DeKalb County House Bill, it creates a local governing authority for the enforcement of the DeKalb County Ethics Code. As the Commission knows, although we are known by the Misnomer State Ethics Commission, we don't deal with ethics. We don't deal with conflicts of interest. We don't deal with the political activities of a county employee dealing with county local elected officials or participating in the campaign. All we deal with is the Campaign Finance Act, state transaction disclosures, and lobbyist regulation. And that's what you have before you today, is lobbyist regulation. Now, Mr. King is going to advance the argument that because the DeKalb County House bill states that the respondent or the DeKalb County ethics officer, that being the respondent, is not permitted to participate in the political activities of the county, she has violated the lobbying code. That's just patently not true. As we can show you, under the terms of our lobbying code, the only thing that we regulate as far as a lobbyist is you have to meet 3 key tests. Are you above the age of 18? Have you been authorized by an entity to represent them? And have you been convicted of a felony within the past 10 years or a crime of moral turpitude? That's the extent of our qualifications. That's the only thing we can deny you for if you don't meet one of those 3 tests. We can say, yes, you're not a lobbyist, don't register with us. There's nothing within our code that says that local governing authorities can limit the class of persons allowed to lobby. There's nothing that says local legislation can limit the class of persons allowed to lobby. So as long as a person meets those 3 quick tests, they can register as a lobbyist. In this case, Ms. Calverman is above the age of 18. She was representing an entity, the DeKalb County Board of Ethics, and the DeKalb County Board of Ethics authorized her representation. They did it on 2 separate occasions, once in October of 2016 and once in November of 2016. Under the terms of our act, she qualified to register as a lobbyist. The difference being, she was entitled to an exemption. She was entitled to exemption I-6 under the code, which says that an appointed public official, which Ms. Calverman is, she falls under that definition under 2153, is not required to register with this commission. And that is a fairly recent update to our law, because if you remember, we used to make like the lobbyists from the Department of Administrative Services and the Secretary of State's office, they all had to come register with us, and then they'd forget about the registration, not file anything, and have a $100,000 late fee at the end of the legislative session. So the legislature changed that law. They said you're a public official, a public officer, appointed, elected, and you're exercising the duties of your office and you're representing your entity, so your constituency. You don't have to register as a lobbyist with the commission. You just show up, you wear your government ID badge, you're good. Now, one thing to note, and I have to draw the commission's attention to, is Mr. Vernon Jones, Representative Vernon Jones, on November 8th, 2017, asked Legislative Council to address the issues in this case. The question was, does House Bill, and I'm paraphrasing, does House Bill 597 supersede the Campaign Finance Act? And Legislative Council said no. They didn't directly say it, but what they said is, Legislative Council reveals no provision in the Act that would render the DeKalb Ethics Code invalid through preemption by the Act. So our Act is controlling, and since we are a general statute, as you know, general statutes preempt special local legislation. Whenever special local legislation conflicts with the general legislation, the special local legislation gives way. And the Legislative Council agrees. They go on further in their analysis to the question of, is Ms. Calderman entitled to exemption under our lobbying code? And what they state is they have a whole discussion about whether the DeKalb County Board of Ethics can appoint Ms. Calderman as a lobbyist. For our purposes, that's irrelevant, whether they have the authority to do it or not. That's a question that's currently being litigated in the DeKalb County Superior Court, and that's where it belongs. It does not belong in front of our commission. And what Legislative Council said was, in assuming that the DeKalb County Board of Ethics could appoint Ms. Calderman as a lobbyist, she would be entitled to exemption under either I-6, which is the public official exemption, or under I-4, which is she's operating as an attorney representing her client. And then finally, it's just, may she claim the exemption? The answer is just yes. She meets the terms of it. She's a public official. She was appointed by a third-party entity. They authorized it. She had no duty to register with us as a lobbyist. And that's the end of the analysis. I know that one of the issues that will be raised is that the argument that somehow the DeKalb County Board of Ethics, because they did an ultra vires act, Ms. Calderman was not authorized to represent them, that she could not legally represent them. Okay, assume that's correct. In that event, Ms. Calderman wouldn't have to register as a lobbyist because she fails one of the three-part tests. She'd only be age 18, not a convicted felon or convicted of crime of moral turpitude, but she wouldn't be authorized to represent a third party. Under that analysis, she'd be her own private citizen representing her own personal interest. People representing their own interest and not representing a third party cannot be lobbyists under our code section. If it did, every good government advocate that went up to the Capitol would have to register us as a lobbyist. So, thank you, Commissioner.
Okay. Any questions for Mr. Lane at this time? Okay, Mr. Thomas.
Thank you, Madam Chair and fellow commissioners. I represent Amos King, and first of all, I would like to say that there's no attorney fee involved in this particular case. I'm doing this pro bono. This is my way of thanking him for his service for the many years, both in a supervisor and a commanding capacity for our United States military, protect our democracy so we can disagree with each other in our country. And so for those purposes, I represent him free of charge. So there's no, this is a pro bono representation.
Mr. Thomas, tell me about his service.
I'd like for him to do that, Mr. Cathy, because I think it would be better for him to do it. Mr. King, will you stand and tell?
Good morning to everyone. My name is Amos King. I'm a graduate of the University of Arkansas, Pine Bluff, where I received my bachelor's. I received a master's in education from Cambridge College in Boston, Massachusetts. I was commissioned as second lieutenant in the Army in 1983 in the Signal Corps. I did 28 years in the military, various, platoon, battalion, brigade, theater, jobs, deputy brigade commander. I commanded. Done a lot of things in the military. The military been good to me. Former athletic director, head coach, and teacher. So numerous things I've done in the community. Right now I represent veterans, make sure our veterans are able to get their benefits and stuff through our community. So that's basically what I'm military career.
Thank you.
Yeah, proceed.
Yes.
Madam Chair, there are some agreements, there are some disagreements in terms of the analogy here. I think first of all, we look at some of the factual basis. It is a fact that the ethics officer was lobbying in an official capacity. That this was not an individual capacity. This was an official capacity dealing with an official subject matter, being legislation that ultimately did not pass, but it is an official capacity action that occurred. The issue here is somewhat the same that I believe that Legislative Council is somewhat in agreement with my position when I say that the DeKalb Ethics Code, which is special local legislation, but still state law. What it did, in effect, it was specific only to the county of DeKalb. In other words, the legislature voted on it, even though it was proposed by the DeKalb delegation, is still approved by the General Assembly and the governor or the people. And what happened is this: as to Title 21, it granted exemptions to people statewide. but then the legislature has the power to come back and take it away from some people. And in this case, only the DeKalb. Only the DeKalb ethics officer did that legislation restrict or prohibit or limit the general legislation, which can be done. This is not a situation where you're asking that one law totally supersede another. That's not the situation. What we're talking about is that has a privilege that was conferred by state law now been taken away from others, a limited category, and in this state, DeKalb County, and that's what House Bill 597 did. Now, we have a situation where I've also indicated in my briefs, I've already put my argument in writing, that we were requesting that this commission ask the Attorney General's office for an official opinion. This thing comes down strictly on issues of law, basically. And we were willing to abide by and live by any Attorney General's opinion, because I believe that we are correct, and I believe that the way Mr. Lane has kind of versed the Legislative Council's opinion is not entirely correct, because I provided you with a copy of Legislative Council's opinion. And Legislative Council ends his analysis by saying, if the Board of Ethics could legally direct the ethics officer to engage in life, well, they cannot. In other words, in order to come before you, it has to be in a legitimate capacity. So, you know, when you ask the question here, was she was not an attorney representing her client. She is an attorney, but she was not an attorney representing her client. She was an ethics officer lobbying on behalf of legislation, and I'm correct, at the direction of the Board of Ethics. Now, the Board of Ethics cannot direct her to lobby. The Board of Ethics cannot direct any employee to lobby. Now, originally, the original motion to dismiss raised no issue about standing. That's, you know, that was not in the initial motion to dismiss. Now, I did receive supplemental brief on December 8th, and attached to that supplemental brief was the personnel description or personnel definitions for DeKalb County, but that does not apply to this situation. Those personnel regulations apply to merit system employees. Ms. Calvin is not a merit system employee. And there's a reason. There is no way that the General Assembly, in this case, passed legislation and stated that the ethics officer shall not, they use that operative word, shall not be involved in the partisan, non-partisan, political activities, or political affairs. Why use all of those terms if they don't mean something? Or political affairs of DeKalb County. Now, it doesn't say that the Board of Ethics, the chairperson of the board, or the lawyer for the board cannot engage in lobbying or political affairs. It says the ethics officer. There's a reason why. Because the ethics officer in DeKalb County under House Bill 597 is akin to a prosecutor. That is the person who gathers the information and complaints, presents it to the board for probable cause, prosecutes the hearing. That is not the person that the legislature wanted to do lobbying. Neither would this state want Mr. Lane to do lobbying. See, I mean, you have to look at what the purposes are. The purpose was not for her. So if we get to the point, was she in fact lobbying? Yes. I think now that's an admission somewhat in the document. That was an admission. Is she exempt? No, she can't be exempt. She can only be exempt if she's authorized legitimately to be able to do something. Can't do that. She was not authorized legitimately. And that is not the issue before the courts in DeKalb County. There are two issues now. One is at the Georgia Supreme Court. I'm sorry.
I'm sorry.
I'm sorry.
23. And I apologize for interrupting. I just wondered if you would respond to what Mr. Lane said earlier, that if she wasn't authorized, that she wouldn't meet the definition of a lobbyist in the first place, and therefore she wouldn't be subject to anything that we would be doing here today.
Well, he said if she was not legally authorized, and that's right, because you know I look at the word precondition that legally authorized, you might not be here. If she was acting in an individual capacity, but that was not the city. She was not legitimate and legally authorized. When a police officer does something, when a police officer searches a car illegally, that still doesn't take it away from being official action.
If she wasn't authorized to be acting on behalf of someone else, wasn't she just acting on behalf of herself?
No, she was acting on behalf of the county. She was acting on behalf of the county. She was seeking legislation on behalf of the county.
Okay, before you go any further
Yes, yes, ma'am.
too, can you speak to the argument that your client doesn't have standing to object to the motion to dismiss?
Well, I understood, as I indicated, Madam Chair, this is the first part of the standing argument that I was presented with. Now, my understanding of the argument about the standing was that he did not have standing to file a complaint. Maybe the argument is that he didn't have standing to contest the motion to dismiss, but we contested the motion to dismiss at the request of the commission. The commission gave me additional time to do so, and I did so in writing. But maybe I'm not understanding what the standing argument was. I thought the standing argument was that he had no standing to register a complaint with this commission about her improper lobby status. But you gotta understand, I didn't
Mr.
receive.
Lane, if you'll clarify, please.
I addressed it at length in the brief, so I won't belabor it too much. But all complaints, even if a complaint's filed by a third party, it starts with the commission. If you read our code, it states that the commission shall institute a case once it receives a third party complaint. That's why the commission has the authority to amend that complaint. For example, if Mr. King had filed a complaint that said Ms. Calderman violated the lobbyist code because she wore a red suit, whatever. And we found evidence that she had done a violation of failure to register because she wasn't a public official. We could amend that suit or that complaint to reflect appropriately what the violations are. The complainants do not control the complaint process. They do not control the prosecution process. They have no standing. They are not a complainant like you think about in a civil action. In fact, when Mr. Thomas first wrote to me on behalf of his client, he provided supplemental information, which a complainant and a respondent are allowed to do to us throughout the investigative process. In response to that, Mr. Thomas asked for additional time in which to file responsive pleadings, and he received correspondence from me stating to him that you are not your client is not a party to this case. You're more than welcome to send us supplemental information, but responsive pleadings, additional pleadings are not permitted under our code section. You're not a party to a case. It's just like a prosecutor's office. You notified us of the violation, we take it from here. One of the reasons I didn't address standing issues because I didn't realize there would be a standing issue until the day of the hearing back in September. So that's just one issue. So I hope I've clarified it. If not, I'm happy to try again.
Do you understand this position?
I understand somewhat what his position is, but as I indicated earlier, this is the first time having to deal with the standing matter. But I believe that this court, this body or this commission still will have the discretion under its rules as to whether or not to allow me to respond. And I think the commission exercised that discretion at the last hearing by directing me to do so. So in a sense, you confer standing upon me. I responded, you know, at your direction.
So, Mr. Thomas, your
Yes, sir,
position
Mr. Evans. Good morning.
Because we allowed you to speak, we thereby gave you standing to oppose the motion to dismiss. Is that your position?
Yes, that is my position because that's what happened.
Is there any legal authority to support that position?
Other than the fact that, you know, we say legal authority, no, I don't have a legal authority because I was not prepared to deal with that aspect. But I'm sure, you know, I could find legal authority that if the commission directs me to do something and I follow the commission's directive, that is a concurrence of some sort.
Mr. Lane, do you have a response?
My only response, Commissioners, would be at the hearing in September, I objected on the grounds of standing, and that the commission allowed the case to be continued so that Mr. Thomas could brief further his arguments and allow his client to attend. Y'all did not confer standing at that point. You allowed him to brief the issue.
that was my recollection of it as well too, and in reviewing the minutes, that the minutes reflect that as well too. Okay, all right, so, anybody have any other questions regarding the standing issue?
No, I just have a comment.
Okay.
You know, regardless of the outcome of the standing issue, we've still got the merits that we have to address either way, and it's whether we should grant the motion to dismiss. So I'm not sure that we, as a commission, have to make a finding on the issue of standing. We can either consider what the complainant has presented in opposition to the motion to dismiss or not. But, you know, I think that we need to get to the merits of the actual motion to dismiss itself.
And Commissioner, sorry, the only reason I'd ask the commission to make an issue on standing is because your cases have precedential value, and I don't think the commission wants to start a precedent whereby complainants start interfering with responsive pleadings of the parties. And I can see it gumming up the works just a tad.
Mr. Lane?
Yes, sir.
Mr. Thomas, I know you don't have access to a lot of goings on over here. at the-
No, sir, I do not,
the,
Mr. Gaffney.
Transparency and Campaign Finance Commission. But I'll ask if you have occasion to know, I want to hear, but I expect Mr. Lane does know. Do we have any precedent before that we allow someone to challenge one of the motions?
Not to my knowledge, sir.
So this would be a case of first impression if we find that standing. You mentioned criminal a while ago, criminal court.
Yes, sir.
And I think what they're saying here is that this commission is sort of like a district attorney, like the state of Georgia.
Right.
Somebody makes a complaint, a crime's been committed, and then it is the state's option what to do that their own. The victim doesn't come to get to comment, make all the objections of what the state does. I think that's what we've got here. And but I'm a little like my brother to my right. I'd like to hear the real merits, but without setting precedent that you do or do not have standing, if we can avoid that. But we try to give people in the public who are concerned about government voice in this place, that doesn't necessarily bestow some right that we can't bestow.
I understand.
Sometimes when your motivation is openness, sometimes things get misconstrued. But if we could just defer the standing issue till we get to the merits of it. I don't want the action of deferring the standing issue to deciding the standing issue that he does have standing. I don't want that to happen. But standing issue is sort of mooted if we go on the merits.
Well, and if I may be speaking out of turn, but I think you could address all of the issues now without making a ruling, and then just address all three issues in your ruling, and that would preclude a precedent that you have standing to come and file responsive. It might solve the issue.
Which is why I asked the question initially at the beginning, was whether we had to decide the first question of whether there was standing. And Mr. Lane, you said no, that in essence we do not, which is what the commissioners have all agreed to, is that we can get to the merits of the motion to dismiss without having to decide the standing
If you
issue.
were to vote on standing at this moment, you would just skip analysis 2 about the superseding of House Bill 597. You could still address it if you felt that was appropriate. But you'd still get to the merits of the motion to dismiss, because we go through analysis of how is Ms. Calvin meeting the definition of a lobbyist, would she be entitled to an exemption? You would just skip one step.
Do we have to make specific findings as to even point two, or do we just vote to grant the motion to this, or you can move to?
I think we could just.
The motion dismiss.
Correct. I don't think we have to make findings. I think we can either grant it or deny it. Okay. Mr. Thomas, is there
Yes, ma'am.
anything further that you would like to tell the commission?
No, ma'am.
Okay.
I made my argument in writing, and
All
I
right.
put the commission to consider it.
All right, thank you. Anybody else have any questions for either Mr. Lane or Mr. Thomas? Okay, hearing none, then I'm going to move that we grant the commission's motion to dismiss. Do I have a second?
Second.
Okay, all in favor? Aye. Any opposed? Okay, all right, motion carries. All right, thank you. Okay.
Can I say something?
Sure.
I won't be a complainer, for lack of a better word. We appreciate you coming, appreciate your service, we understand your motivation. Mr. Thomas is a member of the bar, I always admire those who do so vulnerable people so good work.
That's right.
And I appreciate your professional presentation of this panel myself.
Thanks, sir. Thank you. Yeah, excuse me.
Yes, thank you. And I would echo Mr. Kathy's sentiments, Commissioner Kathy's sentiments.
Thank you.
Okay, moving on then to number 6, which is the late fee hardship waiver appeals, Representative Betty Price, and I've seen Mr. Highsmith here, and I believe Ms. Wetzel, is this your case?
It is.
Okay.
Happy holidays.
We've seen each other's names. Thank you.
Commissioners, this is a late fee hardship waiver appeal for Representative Betty Price. On her behalf, Mr. Highsmith is representing her. This stems from a late fee hardship waiver that Representative Price filed in May 17th of 2016. At that time, she did not present any hardship, so her hardship waiver was denied, and she submitted an appeal on June 1st, 2016. We have scheduled it 3 times, and the first time it was heard, and you denied her appeal, but also left the opportunity open for it to be reheard if she wanted to appear again. This is, subsequently, she hired Mr. Highsmith as her counsel, and we are now finally having the opportunity to have the appeal. The late fee at issue is a late fee that she incurred when she was a city councilwoman for Roswell. It was in 2013. She filed it a couple of days late, and she incurred a late fee of $125. We're just seeking to impose the $125 late fee to collect it from her. However, within the constraints of the code, which only allows hardships to be waived when there is an for waivers to be made is only when there is an undue hardship present, and through her documents and statements, there is no hardship present. So therefore, we denied the first waiver request, and we ask that you deny the appeal as well.
Okay. Thank you, Ms. Wetzel. Mr. Highsmith.
Good morning, Commissioners. Robert Highsmith on behalf of Representative Price. Thank you for hearing from me today. Ms. Wetzel's right. There were a lot before I was engaged. There were some scheduling challenges with this matter being heard, but I'm pleased that the Commission's hearing from us today. Representative Price thought there was a grace period on PFDs in the same way that there is a grace period on campaign finance disclosure reports. She was wrong about that, but she filed on July the 3rd instead of July the 1st, and an late fee was imposed. The lack of a grace period may not be a basis for the Commission to grant this waiver, but I think it's something that y'all should be aware of. This was not just a willful unwillingness to file. This was an honest mistake on behalf of at that time, a relatively new person in public office. The reason you might be, I saw Commissioner Kathy sort of furrowing his brow up there, and I suspect he's wondering what I'm doing here over $125. And that's a fair.
I think we're all wondering that, Mr. Highsmith.
The Vice Chairman's brow was the most furrowed of the 4 of you, but here is the issue. And I want to thank Mr. Ritter and Ms. Wetzel for being very good to me as I came into this matter very late. Ms. Representative Price spent over 3 years on the late fee list. The Scarlet L that you get if you file your stuff late and you're sitting there on the website and it's Googleable and everything else, and that upset her because she never got notice of the late fee. What Ms. Price would say is that had she gotten notice of the late fee, that she could have addressed it then. Instead, she spent 3 years. Now, Mr. Ritter says that we think you probably did get notice, but we haven't been able to uncover proof of that. I look around, I've practiced police commissioner a long time, I don't see anybody in the room that was here running things in 2012. And I just want to express my deep personal gratitude for that, if I may. It is unsurprising to me, if I may, that things in 2012 notices didn't get out to the persons who were subject to the jurisdiction of the commission. I'll let that be that. So when Ms. Price didn't get a notice, she spent 3 years on this list, and now she's like, if I pay it now, I look like a 4-year scofflaw. When the truth is, at worst, at worst, that was a 2-day scofflaw. I didn't realize that until 3 days later. And that's why she's asking for that hardship of having been on the scofflaw list, unbeknownst to her, for over 3 years, until the caucus treasurer in the House of Representatives. She left the city council. She's now on the Republican member of the General Assembly, having been elected in a special. So now she's been on this scofflaw list for 3 years, and that's a hardship, when she didn't even realize she was on it until somebody brought it to her attention. Could have been an issue in the campaign. We all know that ethics filings and ethics issues, however minor, can become issues in people's campaigns and be blown out of proportion. This commission and its staff has done a great job of limiting the ability of people to abuse commission processes, frankly. As a practitioner, I'm grateful for that as well. But that was the hardship. 3 years on a Scarlet L list that she didn't know that she was on. If she pays it now, it's been a 4-year issue. So that's why we're here asking that it be waived. $125. There was no, obviously, I know intent. I know this is a strict liability matter, but I do think it's important as you're considering exercising your discretion, which is what these waivers are, that you know that she filed the thing 48 hours after it was technically due, within the grace period, if one existed for PFDs, which we acknowledge that it doesn't. And she just wants this blot, however minor, off of her otherwise unblemished record in compliance as a public official.
Thank you, Mr. Heisman. Any questions for Mr. Heisman? Comment?
One question I have is, what's the exact definition of an undue hardship? Is it only financial?
Well, I think the word itself, you can use a common sense definition of hardship, and it can range. Now, if we're going to define it so narrowly as to Dr. Price, a retired anesthesiologist, doesn't have $125, well, I lose. It's not that. The hardship is, or if there were, some sort of force majeure type event that prevented her from filing it, we're not arguing that. The hardship is not having received notice. That is important. That's the linchpin of the argument, Commissioner Evans, is that there's no evidence in this record anyway. I've not seen where she received notice. I believe that had this happened today, under this administration, under Mr. Ritter's leadership, she probably would have gotten notice. The trains are running on time around here again, which is fantastic. Not the case in 2012, and because she didn't get notice, she suffered the hardship of being on this this list of folks that aren't in compliance with the law for, instead of a few days, well over 3 years. And that has, without me having stand here, it shows proves special damages. That's it was absolutely a hardship under the commonly understood meaning of that term.
So I have probably a couple of questions more from Ms. Wetzel and Mr. Ritter. I know that we put in place more, so we would make sure that the hardships were being looked at the same way across the board. And we put that into place in what, 2014? Okay. However, I may be recalling incorrectly, but maybe not. I feel like because we had some issues with computers and all that there was a period of time, and there were some cases that we were, because of the backlog cases, where we were making sure that people were treated a little bit differently. However, I don't know if this case falls into that category or not.
It does not. This is a late fee that was assessed for 2013. The commission took notice in April of 2012 that there had been filing difficulties, and in consideration of that, they passed a motion saying that only one late fee would be assessed for all CCDR late fees, and you may have been voted on that, or were you part of the member of the commission at that time? One CCDR late fee would be assessed, and one PFD late fee would be assessed for the period of January 1st, 2011 through April 20th of 2012. This late fee was assessed for 2013. Additionally, this Representative Price filed timely and correctly using the commission's e-filing system prior to 2013.
Okay.
And also just a consideration of how our late fee system in the list works. Just because you pay the late fee doesn't mean that you get entirely off the late fee. It just the list. It shows that you paid the list. It doesn't show when you paid it. It just shows that you had a late fee, it was assessed for a filing, and that you paid it. Or either it shows that you did not pay it. And you were correct about that we do have criteria for undue hardship, and that one being financial hardship, which means that the late fee is more than 25% of someone's monthly income. And then second, if there was a hardship that occurred during the time of filing.
Right. Okay. That clarifies it for me. Okay. Anyone else have any other questions? Mr. Ritter, do you have a comment?
I do have a comment, and I
Okay.
appreciate your hearing me. First of all, I want to thank Mr. Heisen again for being here today, and the assistance to Representative Price. Here's the situation. Representative Price did in fact receive notice, albeit much later than we would have wished, because when we took over, we did send out appropriate notices. But it was on the website before that. I am familiar with the position taken by the prior commission staff, and their position was, you have notice, if it's on the website, you can go see it. The fact of the matter is, it's a $125 late fee. We would have waived it if we could have found any hardship. This is the first time today that we've heard it was a hardship because she was on the list, or on the website for so long. We tried to open the door to resolution of this matter. Frankly, it's not of financial interest to us at all. The fact of the matter is, Representative Thomas did not want to resolve this matter, and it has continued on the list for a long time because they would not simply pay the fee. So it's, to my mind, not a hardship, nor one, respectfully, that the commission can acknowledge because of this. Last year at the General Assembly, I believe it was last year, it might have been the year before, the legislature passed an amnesty related to people who did not get notice and at the local level, and we're still going to have a late fees assessed and so forth, so that they wouldn't have to pay these fees if they file. The governor vetoed that legislation. I don't think that we should go behind that. That's my view. Thank you very much.
Thank you.
Briefly, Madam Chairman.
Sure.
And I also would like to reciprocate and thank Mr. Ritter for working through an issue that is very important to Representative Price and has been, has lingered. Two points. One, you're not setting any precedent with this. This was a 2012 late fee with with the specific issues that we're raising here. I'm unaware, Mr. Ritter may know, Ms. Wetzel may know, I'm unaware of any others that linked with an argument about lack of notice. Because again, with new leadership of the commission, folks are getting the notices required by law. So I wouldn't if you're worried about setting a precedent, I wouldn't. And secondly, I think I heard Mr. Ritter just say this is the first that we've heard about a hardship in terms of being on the list and it being showing as unpaid. As Ms. Wetzel acknowledges, the list would have showed during the pendency of all of this 3 years before we began engaging with, Ms. Price began engaging with staff on it, that it was unpaid. So for 3 years, it sat on the list showing unpaid, causing some amount of damage to Representative Price's professional political reputation. I would point to the 4th page of a submittal that Ms. Price made in an email to Mr. Ritter, the final paragraph of it, and I'm just going to read from it. This was on May 17th, 2016. I am mortified that for 3 years my name has appeared on the late filer list with no appreciation by me that anything was wrong. It's hard to evaluate the damage done. So it was in the early part of these conversations that Ms. Price first raised the hardship that she was suffering that I'm here arguing today warrants this waiver in a case that I submit to you, Madam Chairman, really is sui generis and unlikely to damage the Commission's ability to enforce timely filing going forward.
Okay, anybody have any questions for Mr. Highsmith or Ms. Wetzel? I actually have one procedural question, really for both of you. My recollection is that we had already voted on this, correct?
You have.
And that we found that she was in fact late, correct?
You denied her appeal.
We denied the appeal, correct? Okay, so today's hearing on this would be if there was any new evidence that Representative Price was bringing forward, is my understanding. We left it open for her purely to bring forward any new evidence of a hardship. Is that it? Everyone else's understanding? Okay. Now, Mr. Highsmith, your brow is now furrowed.
It is. I wasn't engaged at the time, Madam Chairman, and
Okay.
so I can't argue with the way that the chair has characterized it, having not been here, other than to say it was my sense and my understanding from speaking with staff that this was more in the nature of a motion for reconsideration, given that Ms. Price, didn't. Again, I wasn't here, subject to correction. I don't think Ms. Price actually made a formal presentation at that time. She may have, but this was the first time that represented by counsel she would be able to come forward and make the arguments that I just made. So I would ask the commission to view it more in the nature of a reconsideration.
Of a reconsideration.
Than than sort of a habeas proceeding, if you will.
Right, okay. And to be fair, I would have to go back and review the minutes of that hearing to know exactly what we said. I'm just trying to determine how we should treat this. I don't recall exactly what the minutes say. And I want to make sure that we're fair to both sides, both to Representative Price as well as to the commission. It would be my I would like to review the minutes for that, so that we can make sure that we're correct on whether it's actually a motion for reconsideration or if we said something to require her to bring forward any new evidence. So I think if anybody else disagrees, speak up now, but it would make me feel more comfortable if we could put a pause on this for the moment and ask our secretary or someone else within the commission staff to get a copy of the minutes from this hearing, where we found that she was that we denied her late ship, so that we can, or not denied the late ship, I'm sorry, again, yes, I swear I had 2 cups of coffee this morning, and although nothing is coming out of my mouth correctly today.
What was the date of that initial?
It was June 23rd, 2016.
I have an observation.
Okay, please go ahead.
one of the challenges of this staff that we have now is taking care of things that happened way before this staff came into existence. And we have dealt with one after another of these things that for a myriad of reasons were unreconciled, reconciled incorrectly, ignored, any variety of conditions that you want to say. And this staff has been remarkable in getting us in the position this commission's in now, including Mr. Ritter and everybody within his commission staff. I would like to say this. I think the integrity of this commission can withstand and sustain a waiver of this late fee. And I'm almost doing it as a way of thanking this staff for what their efforts they put in to doing something like this. And I, for one, would like to put as many of these things that are old and stale and with all kinds of issues why it never happened to bed. And irrespective of what we call it, whether it's a reconsideration, once the chair calls on me, I would move that in light of the confusion, lack of a better word, of this late fee notice, that we reconsider it and waive it. It's pretty simple. I want to put these things behind us, especially one where any blame can be assessed against this commission for late notice, and it certainly was prior to this administration, prior to Mr. Ritter, before any of this happened. It's just a way of cleaning up things that take a lot of time, and it's not. This is not significant, and these lawyers have done a magnificent job cleaning up things like this that take a lot of time for not much money. Of course, we all know that. And this one doesn't have much precedential effect either. And that's what I would do if allowed to make a motion that bad. And but we can take any time to look up minutes that you want to.
Okay, so making sure I follow Robert's rules of order.
Robert, what are they?
I'm with the vice chairman on this one.
You can entertain a motion.
Right, and that's what I was thinking. So I'll entertain that motion. Is there a second by anybody?
Is there something that Ms. Wetzel wants to respond to?
Yeah, I didn't make the motion. I said if we were allowed, that was my thinking.
Okay.
The motion.
If I may speak, I would like,
Sure.
just to speak to the precedential effect, we still do have late fees from 2013 outstanding. So they're $125, and we're still trying to collect those because the statute of limitations has not run. So there is some, because the argument could be made by everyone that their name being on the list is a hardship. So if we're going to do that for this, then
Well, how many of those are there?
I can't give you an exact number, but probably hundreds,
Yes, that's correct.
Okay.
if not thousands.
Right, and of course, we're going to respect the commission's treatment of this, however
Of
you
course.
want to treat it. The fact of the matter is, as time goes by, those cases get harder and harder to collect anyway.
Exactly. I just wanted to make sure that there's knowledge that this is not an isolated late fee, outstanding late fee.
Does anybody know if they're going to revisit the amnesty provision? Anybody heard anything about it?
My understanding is that they're not, but, I can't say what they're going to do. We never know.
Well, I don't want to I don't want to create something that we're going to have to hear it every time we have somebody who legitimately maybe is not in as much good faith as Representative Price. So, but
Do we know, Ms. Wetzel, how many of those did not receive notice or received late notice of the late fees?
So I think maybe we're conflating two ideas. One is there's notice of that you were required to file. Notice of your filing requirement, those I can feel certain went out. As far as notice of late fees, during that period of time, if a late fee was assessed, it was the former staff's opinion that because it was posted online that was sufficient notice of the late fee.
Right,
So there's two different notices. So yes, notice to file, yes, that should have gone out, and I feel confident in saying that those went out. The notice of the act that you incurred a late fee after you filed, I cannot say whether those went out. I cannot say that confidently. However, I do know that with prior administrations, that it was their opinion that it being placed on the website, on the list, was notice.
So my understanding is, so to make sure we're not conflating the two and that we are clear.
That's right. The only, again, had she received the statutorily required notice of the failure, paid it, then the hardship that she's bringing before the commission wouldn't have existed, that 3-year Scarlet L period.
But prior administrations said that the statute was fulfilled by being on the website, correct?
Among a great many other things inconsistent with the act, yes, Madam Chair.
Okay. Okay.
How exactly is that inconsistent with the act?
Yeah, that was going to be my next question.
Sorry.
I should have done that. The website, the notice, and Mr. Ritter, correct me, because you wrote to Ms. Price, I think, about the form of the notice. I think the form of the notice has to be in the same form as the filing. Is that?
Well, not quite. Okay, so if we want to get into the weeds here, I can tell you that under OCGA 21-534K, that governs the notice that's given of late fees. And that notice is statutory to collect the $125 late fee and for that late fee to escalate. Most importantly, although the statute is, in my view, poorly written and ambiguous, the better reading in terms of the respondents is that all notices to them must be certified mail. It does say in the same form as the notice went out or the late fee was filed, but the reality is that to escalate it and for other matters, we treat it as always certified because of the ambiguity in the statute.
So that's why it was not escalated, is that correct?
Correct. It was not escalated until we sent her a certified notice. And I should also, while we're talking about this, let's be clear, I think that when Mr. Highsmith says she did not have notice that she owed a late fee, I think that's correct. I don't think that's the same as her not having actual knowledge that she was late, but I'm not sure that's relevant.
She became aware of the late fee in early 2016.
Okay. Okay, so have we found the minutes?
Yes,
Okay.
yes, we've got it, and I can tell you, looking at the minutes, and I can show this to you, but in the matter of Elizabeth Price, it was motion and approved to deny the hardship waiver appeal, motion by Vice Chair Adams, seconded by Commissioner Cathy, carried 3-0.
Okay.
All right.
Nothing further in the minutes about?
No, those are the minutes. Yeah, that's it.
Okay. Okay, Commissioner Cathy, you indicated that you had a motion, so
Well,
I will call on you at this point to make any motion you may have.
before I do that, Ms. West,
Yes, sir.
what type of motion can we make, considering these unique circumstances, that will not be precedential of collecting all these other, maybe hundreds, of people with late fees? If you say there's not, that is precedent, there's nothing we do. But I would like to narrow it. Now, this is already, we now know this is, if anything, a motion to reconsider. The ruling is unambiguous at the previous, at which I seconded that motion to dismiss. I'm not above rewriting if I need to, but I don't want to hurt your efforts, all your good efforts in the future, but I also want to give due regard for somebody who's in good faith and somewhat a victim of a confusing process that existed BS before Stephanie.
Right, and I agree and I respect that, I do. However, as far as narrowing the motion, because her hardship is not specific to her, it would be hard to make the motion based on her specific hardship of having her name on the late fee list.
Right.
However, you can make a motion granting it and saying that it has no precedential effect, but I don't know if that, I would defer to Mr. Ritter on how to word that or how to cause it, because it's not a specific, these are not circumstances that are specific to her.
Right. I think it has to be handled on a case-by-case basis, and I will tell you that in her case, she has filed a hardship waiver appeal, and she has attempted to litigate this and brought it in front of the commission. I think that it would only be precedential, we should argue or assert that if someone were to do the same thing and to show the same mitigating circumstances.
In light of the discussion, I do have a motion
Okay.
that we reconsider the June rejection of the waiver and pass the waiver of the hardship fee based on the discussions we've had.
Okay, do I have a second?
I'll second it with a point, as Commissioner Kathy just said. I think we emphasize that this is based upon the unique circumstances of this case. The fact that Ms. Price did retain a counsel to appear and in no way diminishes your efforts or Mr. Lane or Mr. Ritter's efforts. With that, I'll second the motion.
Okay. I'm going to, any discussion before I call for a vote? Okay, all in favor?
Aye.
All opposed? Aye. Okay, motion carries 3-1. All right. Moving on to item number 7, preliminary hearings. It appears that 2014-0027 in the matter of David C. Simmons is now a consent order, is that correct? Okay. All right, now that, then we move on to 2016-0046 PC in the matter of school reform 2016. All right, this is going to take a while, I believe, so let's take a 3-minute biology break for everybody. Okay, we are off of our break and taking 2016-0046 PC in the matter of school reform 2016. We had an extensive hearing on this matter at our September meeting. And this case was tabled to this meeting, and I believe everyone that's here today was present at that meeting as well, too. We tabled it for, correct me if I'm wrong, any other commissioners, we tabled it in essence for new evidence to be brought forward, because at that time we did not have any sworn evidence in front of us. And am I recalling correctly?
I believe there was a motion.
There were two.
To find reasonable grounds.
Correct.
Did not carry, that there was a motion to dismiss, which did not carry, which by default put it back on this calendar for consideration of the ongoing complaint.
Correct.
That's right. So I think that we're sort of here for de novo review.
I think you're correct. So, okay, that was my understanding as well, and I just wanted to make sure that we were all in the same. Let's see. Okay. All on the same page. Okay, so that then means that I'm sorry, yes?
As far as being all on the same page, let me just.
Can you use the microphone, please, so that we can all hear you, so you guys see it? Oh, there's not one. Oh, okay, well then just speak up.
Sure. Well, can you hear me okay? All right. Madam Chair, this is John Thomas. I just wanted to introduce him. He's the, I guess, co-respondent. On your issue, also a member of the Muskogee County School Board, y'all know all the background, we've been through all that before. What I would like to do is put into the record, because let me just say, I had I guess it's baptism by fire with my first experience here, and I'm going to do a better job. But I'm here as a lawyer and a respondent. And I've got a responsibility today to build a record, and that's one of the things I want to do. And what I'd like to do now is I'd like to pass out a document that I have created to put in the record. And if I might approach, I guess it's kind of like a judge, I'd like to give it to the court reporter. I've marked it R1.
Can I see a copy of it?
I've done, and so here's the thing. I just asked him to put the thing up on the board so y'all can see it. And he can't do that. So I don't have all that.
Actually, you know what, Mr. Myers, before you go forward and pass that out, one quick question. I don't see in our binders the actual complaint.
I can go print it and bring it to y'all.
Yeah.
Print the notice of additional allegations as well, please.
Yeah, that would be good. I don't have, does anybody else have?
It's not in the binder. It's presented at the time.
Okay. Okay, then let's just pause until we have that, okay?
Sure.
Thanks.
Bethany, how long do you think that'll take?
If I can get the office next door to print it, then it
Okay,
should
thank
only
you.
take 2 minutes, but the other respondents have left.
Madam Chair, while we're waiting for that to be printed, I understand that Mr. Myers has something to present, and I'd be happy to review that and get to that when we get to that part of the case with his presentation. I'm wondering if we could have his presentation after I get done with our initial discussion.
Let me get the complaint first before we go any further, Mr. Ritter. I need to know what but I'm going to throw out some cautions. I'm going to caution both parties to follow Robert's Rules of Orders and not speak out of turn. Primarily because the public deserves to be able to hear this hearing correctly. And since Mr. Myers, for some reason, there's no mic on your table, you're going to have to sit down because the recording is directly behind you of the meeting, correct? And when you stand in front of it and you're not at the podium, the public, when we place these,
So this is the key.
that's actually our court reporters, that's correct. The public, when we place these on our website for view, can't see if you're standing right there,
Okay.
okay?
Yes, ma'am.
Because you're blocking the commission,
Okay.
okay? So because you're not mic'd, you all need to make sure you're following in proper order and not speaking out of turn so that you can be heard when it comes time to place this on the website, okay? So that's a word of caution that I'm going to give to both parties.
Thank you.
Madam Chair. Oh, I'm sorry. Never mind. I'm sorry? No, no. He's smart. Oh. Oh, wow. This is hard to tell you.
When it froze too, trying to figure this out. I don't know what we do. Really? Can you remind me to bring him some apples so I can listen to coffee soup with him?
They keep going to Bill.
He's checking on the key. I already asked.
She's got it, she's.
Hold commissioners on parenting advice. My daughter at 2 now, so it's possible to get out of the house in the morning. She wants to take everything to school with her so she can show them. She goes, I showed Ari, I showed you, I showed people, whatever she's got in my hand. I said, no, we don't need that. She lets me know. And the other day she was sitting there and was taking her to school. She said, no, hey, you're not going to do that. You're not listening to me. She was doing what my daddy said. With just pure confidence. And I said, what did you say?
No.
And she just stopped and walked away. And I was like, oh. She realized that argument was true. Yeah.
That never changes because my youngest, the 15-year-old, the other night, told me all the time, I remember what I was like from him. He said, Mom wants to talk to you. I was like, what?
I saw a cute little sign about her mother. It says, I'm a feeling this grandma. And my daughter's doing that too when she's lost her phone. She'll pick up the phone, she goes, I call Pops. No, Pop would get through. No.
But if it's just them and the grandkids, your parents are weak. That's sabotage you want to.
That's what they can get back to you.
I don't have any grandchildren yet. I've got 3 adult children. No, that's pretty nice.
First time I ever looked at them, I didn't ice cream was not work for me. Even if she likes.
What is that camera about? I'm just kind of, one right over your head.
Do you not know? It's not the one we utilize though for our meetings.
Right, yeah, I'm just, because I know that, I watched the YouTube or whatever on that one.
Okay, thank you for getting that for us, Ms. Wetzel, that helped. Having the complaint in front of us, as well as the notice of additional allegations as well. Okay, so this matter came before us then in September, at our September meeting. It was tabled, and as Commissioner Krakenbull indicated, it is in essence a de novo hearing. Again, I'm going to caution both parties because of the lack of a mic at the table and the camera in the back. And we need to make sure we are not speaking out of turn so that the commission can make sure to get all of the evidence in. Okay? All right. So at this time, then, I believe Mr. Ritter, it is your matter.
Madam Chair,
Yes.
I believe you said you would recognize me after y'all got that complaint, so I could say what I wanted to say preliminarily about this case.
Well, you actually, I appreciate that, but we are going to wait until it's your turn so that we can hear things in turn, okay?
No, ma'am, it's not okay, but I mean, I'm gonna have to live with your decision, but I.
That's
I have
correct.
a
You're gonna live with my decision, and it's Mr. Ritter's turn, Mr. Myers.
Constitution be damned.
All right, thank you, Madam Chair. As you know, my name is Stephen Ritter. I'm the Executive Secretary of the Commission, and it's been my privilege to work with Bethany Wetzel on this case. As you know, the previous hearing, Bethany presented this matter. She is potentially a witness today because as our attorney, she functions actually as an investigator in this matter. Our actual attorney at law is the Georgia Attorney General's office. To the extent I will need to call Ms. Wetzel as an investigator as to her investigation and what she discovered, I'll do that. But let me emphasize, we are here today as a preliminary matter. This is not the due process evidentiary hearing that would be provided in this matter, which goes in front of the Office of State Administrative Hearings. Office of State Administrative Hearings hears contested evidence, both sides and so forth, as to the case, makes a record, and then issues an initial decision. Our hearing today is to decide whether the Commission believes there are reasonable grounds to believe that a violation of the Campaign Finance Act may have occurred. It's a low threshold. As it's been described before, and I'll describe it again, since our matters have been called quasi-criminal, though they're fundamentally administrative, this is very similar to a grand jury type proceeding. It has been the custom, but not in fact either an administrative rule or anything else, to hear from respondents to the case at this stage. I'm not opposing the respondent in this case speaking and presenting matters to the commission. I want to emphasize, though, that today we're here at a preliminary matter. It's not the due process hearing. It's just to decide whether reasonable grounds exist. If it were a true grand jury proceeding, the opposing respondent would not even be given a chance to attend, let alone present information. Again, not opposing it, but I am seeking today to move very quickly through this rather than to spend the several days that a hearing at OSA would take, because we are here at a preliminary type hearing. And in that respect, I will also draw the court's attention to the rule of evidence, OCGA 24-1-4. And as a preliminary matter, this is not one where, say, the fundamental rules of hearsay and so forth need to be implied, but the court, or excuse me, the commission can consider the rules of evidence in the chair's discretion as the chair believes they should apply in this case. We will, of course, abide by any decision of the chair as to how to proceed on the evidence. One of the things that was discussed at the prior hearing of this matter was whether a consent order could be entered into between the parties. I am not going to, unless called upon to do it, to get into the correspondence and exchanges on that issue. But it has become abundantly clear to me that that is not a prospect at this point. We remain open to negotiating if there were a basis to negotiate. Finally, some evidentiary questions were raised at the last hearing, and because of that, we served subpoenas in this matter on the two candidates who were involved, most specifically as having received at least some support from School Reform 2016. Those are Dr. Joanne Thomas Brown and Sheila Williams. We received service affidavits for those subpoenas, and I can tender those if the chair wishes to show that those subpoenas were indeed served.
I would like to see those, please.
Okay.
Can we stipulate?
As far as I'm concerned, you could say so, but I will share anyway.
I'd still like to see them, but if you want to stipulate, that's fine, but I would still like to see them.
Here's a copy for you of the Joanne Thomas.
We've got all that.
Okay, I've sent all that.
They're also located at tabs 20 and 19 and 20 in your evidence binder.
Okay.
Point of clarification, Madam Chair.
Yes.
If he's talking about calling Ms. Wetzel as a witness, I mean, can we invoke the rule of sequestration?
Well, I don't think that applies at the preliminary hearing. Nonetheless, I'm not going to oppose it if you really want to do that.
Well, I don't know if you're going to call her, but I mean.
Well, I hope to not call her.
Okay. First, I want to review these subpoenas, and then we'll make a decision on that.
Madam Chair, those were marked, the service was marked as exhibits 10 and 11. There are actually two subpoena or two affidavits with each showing service on these two individuals. And let me note that neither one has attended, and both have said they can't attend. Because this is an administrative body, I would like to recommend that, since we've already heard this once, that we go forward and at least hear the rest of the matter. And should the commission deem it necessary to hear from these witnesses, then we're going to have the Attorney General's office go to Superior Court per the law, since we do not have contempt power, file an action in Superior Court to require the witnesses to attend. But before we go to that point, because I would like to move this forward, I will say, I'm not sure their testimony is critical, and I think we can move forward on some of the basic stuff. And I will also say that Dr. Joanne Thomas Brown did provide us an affidavit, and I will tender that affidavit. It's been marked State's Exhibit 9. And
Y'all sent it at 9:30 last night, first time we ever saw it. We got it.
we got it last night. So,
You're on. Tab 22, okay. Okay, wait, before you go any further, Mr.
Yes.
Ritter, both of these people, it appears, were personally served, correct?
Correct.
Okay, all right. Okay, and, with regard to Mr. Myers' motion invoking the rule of sequestration, do any of the other commissioners have any thoughts on that?
My thought is to let it go forward and see if it's even necessary for her to present any testimony.
You mean you suggest that you will not be involved?
I mean, I don't know if it will be necessary. I mean, if Mr.
I don't see it. Mr. Ritter doesn't propose to move the vote whether he vote or not. It looks to me like it wouldn't hurt.
Again, I agree with that entirely. I'm not even sure whether we can invoke it, but if the commission's going to agree, or if the commission staff is going to agree, then.
I'm not seeking to put up procedural obstacles. If Ms. Wetzel is asked to leave, well, the testimony is presented, so.
Right, I have to agree with Commissioner Kathy and Commissioner Crackenball. I don't know that we have the power to do that, but if Mr. Ritter is not going to oppose it, then Ms. Wetzel, if you wouldn't mind stepping outside, I would appreciate that.
And only if he's going to call her. If he's not going to call her, she doesn't need to leave. We're not trying to be contentious about this.
Well, you asked for the rule to be invoked,
Well, I
so.
asked if he was going to call her, though, Madam Chair, and I think that's, I mean, I'm not trying to antagonize you, be a problem. I'm trying to get along. I want to stipulate some of these facts in this affidavit. And this email is clearly hearsay. I'm trying to move this along. I really am.
Well, we would be delighted to do that. In fact, ask for stipulations before this
I
hearing.
understood you didn't know whether you were going to call Ms. Wetzel.
I don't know whether I'm going to call Ms. Wetzel or
Right,
not.
so I think to be on the safe side, since he's not sure whether he's gonna call her, I think that we put her out in the hall whether we have the power to or not.
Okay.
Since the commission staff is not objecting to it. Okay.
Right. Well, it may be, given Mr. Myers' viewpoint, that he would like to stipulate some of the facts. They haven't done that, but I can tell you that I don't think the facts are very complex. And I'm hopeful, based on my review of both the materials that have been filed by Mr. Myers and reviewing the transcript of the last proceeding on this, that most of the facts are not in dispute, and maybe none of the facts are in dispute, except for one very narrow issue. And the fact of the matter is, since this is a preliminary hearing, I don't really care whether they dispute it. I just care whether there's evidence to support our position of the case, because the dispute, in terms of due process and so forth, would be considered in terms of weighing the evidence at OSA. Your job today is to decide whether there are reasonable grounds. And if the evidence is presented that shows reasonable grounds, even if they disagree with that evidence that would show something else, unless that evidence is completely not credible, I think there are reasonable grounds. Just like any other matter where you would have essentially a probable cause standard, it doesn't matter what the full amount of the evidence is, it's just whether there is some quantum of evidence to support it. But nonetheless, if I could, let me proceed then to some of the details. And if there are questions or evidentiary issues that arise, I will be delighted to put forward evidence to try to support those issues. May I do so, Madam Chair?
Yes, please. go
Okay.
forward.
This is on PowerPoint. I'm going to step around so I can see the screen, but just over here to the side so I don't block.
Okay, and this screen over here is actually not working, which would probably be a little bit easier.
Right, but I know what's on the PowerPoint well enough. Just
No, not for you, but for Mr. Myers to be able to see that a little bit more easily. Can we have that screen?
Not from one computer, but I'm happy to run it.
Madam Chair, we'll just can we just scoot around a little bit and that'll solve your problem?
I'd actually rather you not because of the way the camera is set up. Sorry,
This camera?
correct.
Bear with me just 1 second.
We did try to set it up this way earlier, so it's on both.
Just don't advance your words when we show no problem.
Pull it out and go ahead and make a copy of it. Thank you.
Do you have a hard copy of it?
Unfortunately, I don't.
Okay.
We could make one if you'd like.
If that's gonna be faster than trying to get it to come
No, it
up.
won't. It should only take a few minutes.
Okay.
Yes. Madam Chair, I'm going to discuss with this council for just a moment.
Sure.
Mr. Myers,
So,
to try to streamline this. This is printing.
I mean, we're stipulating we pay for a website, so we don't need to do that.
I won't necessarily, but we'll just say stipulate. These are the checks, some of the checks anyway. You want to look through those? I can give you a call.
Okay, so on this.
Sure.
Here, step back. If you will stipulate that the amount at issue in this, excuse me, step back, please. If you will amount, that the amount of controversy for this hearing is $4,858, is that your position?
I believe so.
If you will stipulate that that's all that's all this hearing is about, I will stipulate that amount.
Okay, there's a slide coming up on that, and it doesn't go over that.
Okay, again, I need a yes or no answer. If you
The answer is yes.
Okay, and that is the amount in controversy
Well,
in this hearing.
Mr. Myers, I don't know what amount in controversy means,
That-
but that's the $4,800 some dollars. That's the total amount that was paid on the runoff election for the variety of things that were paid for. Okay.
That's the figure you're.
Okay, gentlemen, if you want to,
Yes.
okay,
I think we have an agreement, if you'll just put it on the record.
Yep.
okay.
Okay, so, to clarify the evidence here, first of all, and if I say something that is incorrect, please correct me, of course, Mr. Myers.
With the chair's permission, I'm not going to say anything.
Right. So there was an organization, School Reform 2016, they're the respondent in this matter. That organization was created by Mr. Myers and Mr. Thomas, who are both here today. There was a primary election, and they provided direct contributions to several candidates, including Sheila Williams and Dr. Joanne Thomas Brown. We don't dispute that. There was a runoff election in which Dr. Thomas and Ms. Williams were involved in. At that point, advertisements were run on television, and in addition, other things were paid for in relation to that ongoing campaign. And the total amount of that was $4,800 some dollars. There's a slide on that. We won't parse the checks. Some of it went to television company for the ads and some other things that were paid for along that. But the total amount was about $4,800. And the one issue that could be in dispute, but tell me if it is respectfully, Mr. Myers, is the extent that Joanne Thomas Brown or Sheila Williams cooperated with the television ads, particularly in the runoff election.
May I speak?
Sure.
Thank you. Okay, so the germane part of this in my mind, and the agreement I felt like we had reached, and I think maybe we have, is that what is before this body to figure out is the $4,858. We have now narrowed the issue that's going to be heard today, and that is what I call the amount in controversy, or the amount that you will pass judgment on. We're not talking about any other expenditures. It seems like to me that the position's now been taken that we made some independent expenditures. We accept that they're making that argument. We're not concerned about that. We will have our say, as you said, Madam Chair. But just to make sure everybody understands, we're talking about $4,858, and that's the ball of wax that we're dealing with, and that you will decide upon. The rest of this stuff is off the table, correct?
Well, I don't know what the rest of the stuff being off the table really means, but I can tell you that we're, in terms of money that was spent on the primary campaign, not the runoff, off the table. Okay?
The 4858 is the runoff.
That's the runoff, right? And we certainly agree that's the appropriate amount for that. That's the relevant amount. Nothing spent on the primary is relevant.
Thank you.
Okay. All right, Mr. Ritter. Thank you both for agreeing to that one. Okay, let's move forward.
Okay, thank you very much. So it is on the side screen as well. Thank you. I'm going to try to move through this fairly quickly. There are two issues that are in front of the commission for a determination as to whether there are reasonable grounds.
And I'm sorry, before you get started into the meat of it, I just want clarification for the record that Mr. Thomas, who is here today, is in no way related to Joanne Thomas Brown. Is that correct? Okay. Okay.
No.
Just making sure for the record.
That's right.
Okay.
And there's also two Williamses, and they're not related either.
Okay.
So.
Thank you.
Okay, very good. So there are two issues. Originally, as Ms. Wetzel stated before, we were contacted by the election superintendent in Muskogee, Columbus County about this. They don't file written complaints. They function essentially as the agency's agent when there's a violation. It's our duty to investigate. We did investigate just to see if there was something. There's plainly probable cause in our view. And a complaint was filed asserting that they were functioning as independent, they were making independent expenditures and therefore were independent committees and were subject to registering and then filing as independent committees. And that's covered by the specific statute cited up there, particularly 21534F. The response to that, among other things, was that no, we're not independent committees, we were a PAC. We always said we're a PAC, we're a PAC, and as a PAC we made contributions to these candidates, Sheila Williams, Joanne Thomas Brown. There's no question that indeed they did make direct contributions to these two candidates for the primary election. And in fact, that was shown on the CCDRs of Joanne Thomas Brown and Sheila Williams for the primary election. So they were duly reported those. But they went on to a runoff. A runoff is a separate election. There's new limits that apply at that point. So then the question is, okay, were those limits exceeded? Which brings us, go back if you could, bring us to the second issue. If they did make contributions for the runoff election, were those contributions over the limit? The fact of the matter is, and this was discussed at length and we filed a brief on this issue, we understand that they disagree that if they were a PAC, they say they can never be an independent committee. But there's already an advisory opinion that plainly says, in fact, yeah, you can be both. And for the runoff election, it is our belief, based on the investigation, they did function as an independent committee. But if they didn't, if they were a PAC during that period, then in fact, the amounts that they expended would have been in-kind contributions and they exceeded the contribution limits. So let's step through this real quick. getting a Skype for Business thing coming up online. Yeah, thank you, Microsoft, for your notifications.
Might be Joanne Brown.
No, that's Skype wanting me to sign in. Okay, so independent committees requirements. Independent committees, this is a statute, 21.534F. Independent committees accept contributions or make expenditures for the purpose of affecting the election or defeat. So they're making these expenditures for the election, and if so, then they have an obligation to register and file disclosure statements. If we look at what an independent committee is, first of all, something other than a PAC, and we understand that to mean other than a PAC for the purposes of those contributions. And they receive donations, and they expend the funds to advocate the defeat or election of the purpose. There's no question that those things happen. The only question is whether they were direct contributions and they functioned as a PAC. In this regard, we should note that independent expenditure is defined regulatorily by our commission, as it is by commissions around the country and the feds. And it means an expenditure which is made by the independent committee, not made in cooperation or consultation or concert or request with the candidate. So the law is set up as such. If you make an expenditure to influence an election, but you do not coordinate it with the candidate, and you don't give it to the candidate, like don't write him a check, then you have made an independent expenditure, so you are an independent committee. On the other hand, if you give it to the candidate, then for that expenditure, you are a PAC. For any expenditure, you can't be both an independent committee or a PAC. We're on what is a PAC. So, what is a PAC? Consistent with what I just said. A PAC is defined as committee, club, association, and so forth, which contributes funds to one or more public candidates, etc., for public office. So if the contribution was to the candidates, then they're a PAC, and it's a contribution. If it's not a contribution, but it's an independent expenditure, then it's not one that would be subject to the contribution limits. Hold on, let me come back to that. But I'll come back to, it's not subject to the contribution limits if it's an independent expenditure. There's a regulation I'll get to in a moment that says exactly that. So PAC is a contributor. An independent committee does not make contributions. They make their own expenditures. And the key here being that if you're an independent committee, you're not limited by the contribution limits. You can expend how much you want and don't have to worry about violating that aspect of the law.
What is a campaign committee? How are they distinguished?
Okay, a PAC, here's the definition of PAC. And here's the interesting thing, by the way. I'm going to go back here. I know it's hard for you to follow.
Campaign committee is used in the other definition too. I know
Yeah,
you know what
well,
it is.
let me just say this real quick, okay? Okay, here I've cited 21.5.315 definition of what an independent committee is, and then before that, independent committee requirements, right? The PAC, there is no similar statute to this for PACs. PACs are only mentioned by definition. PACs are treated, however, as any other individual contributor. So, in terms of filing with us, if you had to register and file if you were a PAC, which they did not do, and we do not say they had to do this ever, you have to cross a $25,000 threshold to do that. They didn't get over $25,000. So they don't have to register as a PAC. But they still have to comply with the contribution limits. So even though they haven't registered and filed as a PAC, which is entirely appropriate, and we do not ding them for that, they still must comply with the contribution limits. Here's what they are. No person, corporation, political committee, or political party shall make or candidate receive these contribution limits. So you can't make contributions over this amount. Those amounts actually are higher than they're shown in the statute. That's a quote of the statute because of our inflation adjustments, but they're only a few $100s higher. Okay, so $1,000 for a contribution. Okay, plus inflation. That's what the contribution is. So now we come to this question. Here's the amount that they discussed. No more Pat and Kathy expenditures. These are solely expenditures in the runoff election. I'm going to flip back for a moment. You can see that the contribution limits are separate for a runoff election. There's a primary and there's a runoff. $1,000. And that applies to anything but a statewide office. Okay? So, no question, we just stipulated they spent $4,858 on this runoff election, on these ads. So here comes the rub. Either they were an independent committee, in which case they had an obligation to register and file from the inception with the commission, which is what Ms. Wetzel thought on her initial investigation and complaint was the case. And that's, in her view and our view, probably the most benign interpretation because it's just a failure to file. Or else they exceeded the campaign contribution limits by making direct contributions. Those are in-kind contributions. Though I don't have a slide on that, we define in-kind contributions in our regulations. And I will tell you that anything that is a payment that's intended to assist or contribute to the candidate is an in-kind contribution. If these ads were, as they say, as a PAC, which would be as a contributor, that's their claim, then they were in-kind contributions and they exceed the limit. Frankly, I don't think that is the case. As the affidavit, and we would have expected the testimony from Dr. Thomas Brown and Ms. Williams would have shown, and I have an affidavit from Dr. Thomas Brown that supports this, the candidates were not consulted in the making of these expenditures. These were independent expenditures. So it's a television ad. I won't play it. This just is, do not apply if they have to be independent to be independent expenditures. And our view is that they were independent because these candidates say we're not consulted. In addition, we have the evidence of the CCDRs that were filed by these candidates. They duly listed for the primary election contributions, but they didn't list any contributions for the runoff election from Stop or School Reform 2016. So they certainly thought these were not contributions, which would make them independent expenditures, and which means that they function as an independent committee for the purpose of the runoff, even though they were clearly a contributor for the purpose of the primary. Okay, we could play the ads. I will not do that unless you guys want to hear it. That's what we got. The bottom line is the ads themselves, and I think that they will stipulate to this, don't actually mention the two candidates they assert they're contributing to. Ms. Williams, Dr. Thomas Brown, not mentioned in these ads. These are ads because they do not like Pat and Kathy. And I will add one thing to this. That's entirely in their right to do that. No one here in our office has ever taken a political stance in this case. We don't care whether Pat and Kathy are elected or not. That's not our issue. Our issue is this. If you did make independent ads, which appeared to us to be the case, based on the evidence, then they were independent expenditures. You functioned as an independent committee. You had to register. You had to file. If you really were truly a PAC, as you claim, for the purposes of the runoff, sorry, then the cost of the ads, as Ms. Wetzel carefully looked at, and the cost of the other things they did, easily totaled more than the $1,000 plus that you could make as a contribution for the runoff. So that's our position, and that's why we believe that reasonable grounds exist. Thank you.
Can I ask one question,
Of course.
just as a procedural point before we hear from Mr. Meyer? All we have to do today is find that there were reasonable grounds to believe that the act was violated. We don't need to decide whether they were acting as an independent committee or a PAC. Am I correct?
That is correct.
All right.
Okay, again, and to emphasize this, we go at, if you should find reasonable grounds, it then goes to OSA, should the case not be able to resolve. OSA will have a full, both sides present evidence, witnesses come, we'll have a dog and pony show, 2-day trial, and when that gets done, initial decision is issued, comes back to you to review.
If the respondents here wish to subpoena witnesses at OSA, how do they do it? You told me how you did it, get the Attorney General to...
Oh, the same thing, well, I can tell you that they can file an action. If OSA issues a subpoena and they don't comply with that, they can go to the Superior Court and file an action to enforce that subpoena. The Attorney General only does it for us because they're our counsel.
The subpoena will issue from the OSA court,
Yes, sir.
just like in court's record.
Yes, sir.
And one question from me, Mr. Ritter, before Mr. Myers presents. You indicated that an independent committee has to register and file at inception.
Yes, correct.
What is the commission's position on when the inception would have been for school reform 2016? If it was in fact an independent committee?
The inception would be as soon as they knew that they were going to make expenditures, such as ads, that they were not working with or giving to the candidate. So when they decided, hey, we're going to run some independent ads, at that point, they became an independent committee. I can tell you if they didn't make any expenditures, we would consider it a nullity. So once they have made those expenditures, that is the absolute deadline to register.
Okay.
Okay?
Any other questions for Mr. Ritter? Any of the other commissioners? Okay, Mr. Myers.
Thank you, ma'am. Back to the document I gave the court reporter, if I have permission to pass that out to the members.
Sure.
And so I'm going to have to be a little out of order, and I apologize. I do some background. You're welcome to see this thing if you can figure out how to open it on this. I've got 2 files. Are you going to put it on screen?
Mm-hmm.
Okay, like I said, I'm going to let you know which file to open. That's fine. I just kind of do this. Thank you.
Yes. Which one?
Commission update.
Do you want to be in charge of advancing the slides?
No, that's just for, the commission's got the paper, and I just want y'all to be able to see it as well. Has he got your copy? Okay. So the reason I presented it, or put this together, is really just as it says, to give an update as to what happened since last time we were here, because I didn't expect to be back here, and I certainly didn't expect John to get put under subpoena. Madam Chair, would you like me to talk while y'all read, or would y'all rather just read?
Give us just a moment and let us
Thank you.
read through this.
Yes, ma'am.
Actually, that's not perfect. Actually.
Okay. Mr. Myers, you may continue.
Thank you, ma'am. At the last meeting, I think Mr. Cathy especially expressed some interest in knowing about this GBI investigation that we talked about with asking the Superior Court judges and the governor to get involved. Does anybody care for an update on that? Okay. What has happened since then, the Chief Judge McBride, Gil McBride, wrote on behalf of the judges of the circuit and said, after discussing this matter at our monthly meeting last week, we are unable to comply with your request because one or more of the situations you mentioned may be under active investigation by local or other law enforcement agencies. And even a further update, on Monday, John and I met with for an hour and a half with somebody who's higher than the district attorney. Let's just put it like that. In criminal law enforcement, it makes me real nervous to even talk about it because it's a heavy situation. Update as to the governor, we did not hear back from him in any form. The argument I was trying to make, and I guess we got crossed up earlier, Madam Chair, was a constitutional argument that I just want to put on the record that I think could perhaps short circuit this entire matter, although we are ready to talk about the merits. And I understand that y'all are putting back together what used to be the Ethics Commission, and I saw through the paper, the internet or whatever, we don't get the paper anymore, but this body, or what y'all are trying to do, has been through a rough time in years past. But we all know that protections, constitutional protections, are given for life, liberty, and property to individuals like the other respondent, John Thomas, and I. This is true on the state and federal level. This is a government agency. You have the power to fine people who come before you. That is, you have the power to take. It's a taking. Take my property. In this case, it's my money and John's money. They want $6,000 for us allegedly overspending by $3,000. In September, y'all were impaneled. You heard arguments. You heard evidence. And at this point, back in September, you've already voted on the fate of this matter once. A vote was rendered. There are no new issues. Everything he said was part of the presentation last time. The commission did not listen to the second part last time for whatever reason. I'm not being critical. I mean, it was before the commission. We didn't get to it for whatever reason y'all decided. An attempt is being made to relitigate this case after a vote by the commission, and no probable cause was found the first go-round. Now, the bottom line of what's going on here today is there's an attempt to take another bite at the apple. And I just don't believe this is going to pass constitutional muster. I'm not a constitutional expert, but I learned a lot, and I've always had a keen interest in constitutional law. I think it's clear enough, we're not going away. And that's not a threat or anything else, it's just where we are in life. Our reputation's too important for this. And what I'm asserting is that if this matter continues to fester, it would be a violation of John and my constitutional rights to due process because it would constitute double jeopardy. Jeopardy attached, in my view, and I think it's a reasonable position, when the first two votes took when we were brought up here before. And now, John has been subpoenaed to come up here, and we've been summoned to come back up here. But, I think if this thing goes any other way other than an immediate dismissal with prejudice, a can of worms is going to be opened up that's going to be impossible to close. A couple of other ways to look at this that, the strength, I guess the thrust of their argument is based on an advisory opinion that's been issued by one of the litigants. Advisory opinion is not something that we go and use to take money out of people's pockets. And I'd ask before I even have to present a defense, that y'all entertain a complete dismissal with prejudice. So again, as I asked in September, so we can get, that was me then, but so John was not called and he has to work and he's not as flexible. But I just ask that that somebody make a motion and dismiss this with prejudice so we can move on with our lives. And if that's not your pleasure, I'll be glad to go further, but I mean, I just think every second that this goes on, we continue to be damaged. So with that, I can either go to the next section or, I'm ready to listen if I need to listen.
Okay. Do any of the commissioners have a preference for one or the other? No?
It seems evident to me, having reviewed the transcript from last hearing and responding to Mr. Cathy pointed at me, that the commission first did not, in fact, vote to dismiss this action, as the chair noted, so it's here, and it's properly before the commission today in complete procedural due course. I would go on about the nature of this as an administrative action and how a dismissal would not be of prejudicial effect, because there's no double jeopardy in a case like this, nor is there, in fact, since we're not even through a hearing, there would be no final order, so we could still litigate this case or go forward if we had additional evidence. Regardless, we brought evidence, and they've stipulated today for the first time this is the evidence, so it's in front of you. So if they're making a motion to dismiss orally, obviously we think it's inappropriate. That's not supported by the record. And I will add, I will go back to the email. I am ready to do that because I disagree. I think the record does not support a number of the assertions in the handout that Mr. Myers gave you. They are incorrect. But before I do that, because I think going into negotiations is unnecessary, I'll just tell you I stand against those, but I would certainly oppose a motion to dismiss, since that was already not granted by the commission in the previous hearing.
Okay, so Mr. Myers, am I understanding you correctly that you are making an oral motion to dismiss?
Do I have the power to do that? I do?
I believe you do.
Okay.
Yeah.
Okay, well, I'd certainly, with the understanding that I get to finish my presentation if it fails. I mean, I think we went on the merits.
Is your basis of your motion res judicata?
Yes, sir.
That's the basis.
Yes, sir.
Okay, so at this point then, since you've made a motion, and then I believe then Mr. Ritter has the opportunity to respond to that motion. Does anybody have any questions at this time?
For res judicata, I believe there has to be a final order. So I don't know if there's a final order for it to be applicable.
Well,
go ahead.
Yeah, I just look.
My point was, you've said this issue's been decided before by us. It's the same posture, the same.
Yeah, well, the point is, it was tabled, and I didn't like it at the time, but I couldn't do anything about it. But the point is, this has been heard, and my property has already been at risk before a governmental agency that has the power to take my money and John's money. And that's what I'm getting. This is a due process, double jeopardy type analysis. And I know y'all got better things to do. I mean, y'all are talking about a $125 fine from how many years ago, like 2012 or something earlier. Y'all don't need this on your plate, and I don't want to be here anymore. And this is to me, it's entirely reasonable that, they've had their bite of the apple. He's already been given his, I'm trying to stop the second bite from being taken. I'm trying to, as soon as I can, that's why I wanted to do it early on, Madam Chair, and that's why I didn't mean to be snippy or whatever. But I don't even feel like John should have been having to miss work today.
Okay, so you are in essence filing an oral motion to dismiss based on
The constitutional argument that we are now subject to double jeopardy.
Okay. All right, just wanted to make sure I was clear. and
Due
the rest of the-
process, double jeopardy, however you want to look at it.
Okay, I just want to make sure I was clear and the rest of the commission was clear. Okay, all right, so Mr. Ritter, I believe you have the opportunity to respond to that motion at this time.
Okay, thank you, Madam Chair. To be very brief, I'll quote the commission, or the transcript of the hearing on this last time, just in part. Commissioner Adams, so at this time, it is tabled effective for failing either motion and will go on our December agenda at this time. Okay, well, no final ruling on that case, no double jeopardy. The notion that at a preliminary matter there will be double jeopardy is, well, it's just wrong. I can tell you that if we're a full grand jury that were to decide this, and you were to decide, well, we're not going to find charges at this time, the grand jury could reconvene and reconsider it. Happens frequently. Not double jeopardy. It is not a violation of constitutional rights. It was not previously decided. In fact, it was agreed that it would be continued to this meeting. And that's where we are today. And I agree, we need to move forward. I think this motion is a time waster.
Okay. Do I have any motions from the commission?
Would it be in the form of a motion for the commissioner, or at least vote on a motion that is made?
I think we have to make a motion to either object or to either grant or deny the motion to dismiss.
I'll make the motion to deny the motion to dismiss.
And I'll second that. Okay, all in favor? Aye. Okay,
No.
no, okay, so 3-1, it carries 3-1. Okay, Mr. Myers, so if you'll continue now with your presentation on the merits.
And I appreciate you letting me perfect the record,
Sure.
Madam Chair. The hearing got started off by the notion that this issue was tabled for the purpose of the parties being able to present new evidence. But in reality, if you look at the transcript, it was tabled for the purpose of trying to reach an agreement with a consent order that obviously the staff did not act in good faith. I just think that needs to be pointed out. And I got just 3 or 4 things that have happened. I want to correct the record before I get to the meat of my argument. And the meat of my argument will not take very long. I think I may have covered this, but there's absolutely zero legal precedent that a PAC, that a person can be a PAC and an independent committee. And that's not really germane to what the argument I'm going to make. But there's an advisory opinion that I talked about a few minutes ago. The idea that the commission staff was somehow able to go through and pick and choose what expenditures were allegedly independent is baffling to me, because the evidence was from the transcript earlier, only 2 days before that September, I think it's 21st hearing, it was a Tuesday, that Ms. Wetzel said she called these 2 ladies, Ms. Williams and Ms. Thomas Brown, for the first time. This was a case looking for a theory. And I want to be real clear. The idea that these ladies did not know what was going on generally with the website and the TV commercials is insane. We met, and I could put John up if we needed to, we met regularly with these ladies. In fact, they keep wanting to show this TV commercial. I almost want you to see it so you can understand what was going on. I told them in my capacity as a political consultant that this is an independent deal. A PAC is not part of your committee, and these commercials are going to be hot and they're going to get a lot of attention, and you need to stay 100 miles away from them. That's what really happened, and that is nothing that they have put in their affidavit. I'm sorry, give me some more work. Affidavit or the email from Sheila disputes that. And I almost would like for y'all to see the commercial. It's 30 seconds, so you can understand why I gave them that advice. They knew what was going on. It was just a political calculation so that this would not splat on them. And when I told Ms. Wetzel early on, we were sharing information, everything was going good. I said, look, we were a pack, and we didn't come close to $25,000, and she said, there's no way that you got, the attention you got for the money that you're saying, and now we all know it was like $10,000 or $11,000, $12,000. Wasn't close to $25,000, but the commercials were horribly inflammatory, and they didn't work. But that's the reason they talk about, like they were going to pick out the producer, or who was going to produce the commercial. But no candidate knows who to call. That's my job, which I was, by the way, pro bono. Glad to do it. Just trying to get rid of the corruption in Muscogee County. So this theory was born 2 days before the September 21st hearing. By the way, and I'll put this in the record, you can take my word for it. Joanne Thomas Brown contributed $1,000 to School Reform 2016. You think she gave us $1,000 if we weren't working closely with her to make sure her money was going to be spent wisely and prudently? Do y'all want this in the record, or do you care?
That's up to you.
Okay, well, I don't think anybody can dispute that's what this document is. Ms. Adams, you asked for a copy of the complaint today, and you can see clearly on the face of the complaint that the allegation is we're an independent committee, and they did all this discovery. Didn't tell the truth about some stuff. I mean, we absolutely responded to the 2 subpoenas we got. We shared information freely, early, until we realized, I believe, and I believe this day, that the staff was not working in good faith with me. And I'm just trying to be diplomatic about that. They littered the state with subpoenas trying to find information. We gave them a lot of information. You can see, he knows that. You can see it in the email trail until I just lost faith that they were looking for the truth as opposed to trying to build a case. But the complaint, back to that, it alleges that we were an independent committee, and they did all this discovery based on that. And when I complained to Bethany, I said, if this was federal court, you get sanctioned for doing this, because there's no evidence that we're an independent committee. And here we've gone through all this discovery on this. I just think, and in fact, and this issue's not going to die. Mr. Ritter, I want you to understand, they illegally accessed John Thomas's personal financial information. And that can't stand. That cannot stand. All right, I'll get to the meat. For the next couple of minutes, Mr. Ritter, if I get something wrong, I want you to straighten me out, okay?
Sure.
Because we agreed this morning on some things, that the issues have now been narrowed down. And it all goes to that $4,858. No longer is there even a claim. Well, I can't say that. The issue is, the issue is not really how these expenditures were made, but I'll get to that in a minute. But we now know also, because we've narrowed the issue, that the runoff money is all we're here about now, $4,858. Ms. Wetzel, here's the most important document that we will have. Can he approach?
Sure.
Thank you. Ms. Wetzel and Mr. Ritter's position, as repeated again today, is that there is a limit on contributions for the runoff election. That limit is $1,400, Mr. Ritter?
With the interesting, or the, that's around that amount, yes.
Well, it's not around, and this is important. We've got I'll go to the transcript. Ms. Wetzel actually said it's $2,600 for the primary, $1,400 for the runoff, $4,000. Okay. But their math says because they claim there's a $1,400 limit on the runoff, so you double that because these commercials and this website was to benefit both these two. I think that's a reasonable position. We don't have any argument about that either. So that's $2,800, but based on their, the amount of controversy, what we talked about earlier, we spent $4,800 roughly. So we were over by $2,000. But the law is in front of you right now, and I didn't have this law when I was here in September, but I kind of stepped on it and asked Mr. Cathy how many times he'd maxed out the candidates statewide, and I should have done that, and I felt foolish for it. But the point is, I had to believe that our spending would be in concert with that type of accepted contribution. Well, I didn't have the law in front of you then, but I do now, and it's clear. And this is the commission's own regulation. I gave them all away. I don't even have one to read. Can I have it back, Mr. Ritter? I bet you know that. The key word is when aggregated. When aggregated, when total. You got 2,600 each. 2,600 each and 1,400 each. Let's see, did I have that right? Yeah. What do you think it is?
It's, by your calculation.
Everybody said there'd be math.
Yeah. It's $1,400 for the runoff election by statute. That's with the increases for inflation.
Oh, no.
It's in the statute, black and white.
So how much in the, are you saying in the primary?
As you said, the primary doesn't matter, but the primary is higher than that.
Aggregate spending does matter. So 2,600, correct?
That is, I mean, we can look up the number, but it doesn't matter.
Well, all right, I'm sorry to have to delay, but will y'all take notice that it's 2,600 and 1,400, or do I need to look it up?
That's correct.
Yeah, I'm not willing to quibble that.
Okay, so that's $4,000 per candidate. We have two candidates. That's $8,000 aggregate, which is under Commission Rule 189-6.04. You count it in the aggregate. $8,000 minus the amount we have stipulated, $4,858, leaves us $3,100 and change in the clear. Now, it's disturbing because we're getting this reaction here. They've known this all along. This is all they do. And that's all I'm going to say about that. But that's very upsetting for somebody who has been dragged through this for now 17 months. And the last point I want to make, and this is what really bothers me, is I said last time I was here, I was trying to seek the truth. I guess I'm just a little old-fashioned. But if you look at page 6 of the brief that was filed just last week, right under section 2, they start off citing the actual regulation that shows that the contributions can be done in the aggregate. But they cite it, but then they don't tell you what it is. In fact, I would say that they kind of mislead the reader about what the result of that is. But 189-6-.04 could not be clearer. We're $3,100 and something in the clear based on the amount of controversy. And I would respectfully again ask the commission, and this is real important, to dismiss this with prejudice, because that's the only way we're going to get peace in Muscogee County. And again, renew my plea to just let me get in my truck and go home. And I thank you for your attention and time.
Thank you, Mr. Myers. Do any of the commissioners have any questions for Mr. Myers?
I would, Mr. Ritter, if you could respond to this in the aggregate argument.
Yeah, and also, the phrase in that statute, in any election, does that mean primary runoff either, both?
Right. That's per the election cycle, right? Each one of these is an election. Whoop.
The cycle's all the elections.
The way it's broken down by statute, and this commission would not have had the authority if it had purported to change the statutory requirements, is by election. The runoff election is a different election than the primary election. So there's separate contribution limits for that. We stipulated.
Let me ask you, are you defining per election as both the primary and the runoff?
Under the aggregate to me means, I mean, the word wouldn't be in there if they weren't talking about the whole shooting match.
Well, that's not the phrase I'm.
Okay, I'm sorry.
The phrase is any election.
In any election.
In the statute,
It says, no political committee shall make
That's
for any
statute.
election.
You pointed
Any
out.
election,
Right.
Now, is that any election, meaning the election of the school board, or the runoff, or the primary, or combination?
Well, this is-
My plain reading meant the race that was being voted on and run. The runoff is what I interpret that to mean. I could well be in error, but I read that as that election, meaning where people go cast ballots.
That's the way I read it as well.
How do you interpret, I would just say, when I'm running for office, I'm in an election, whether there's a runoff or a primary election or runoff election, I consider myself a candidate in an election for a school board seat.
So that's,
I think the key word respectfully is aggregate. Aggregated.
Yeah, it's aggregated for any election, though. You
Correct.
have to go back and look at the
Why
any
would you use the
election
word aggregated if you're talking about one election?
you're talking about multiple contributions.
within that one election.
Yeah, within that election.
It's gonna-
I don't think that's an unreasonable interpretation.
Contributions to any candidate. Go ahead, make, I'm sorry. No.
All right, go ahead, Mr. I'm sorry to interrupt you.
No, thank you, Mr. Cappy. No, it is per election. The runoff was an election. There's a contribution limit I've shown for that by statute. The commission could not have changed that, and it didn't purport to. We stipulated to this amount for the runoff election. Now, it's very clear we were stipulating to that for the runoff election. If we wanted to compare apples and apples, then I could show you the amounts they spent on the primary. But I think it's a dead issue. I'm going to tell you for a fact, they overspent for the runoff, plainly. Even some of these exceed the individuals. And of course, his idea that we also have to divide it in half because each one gets half the benefit, there's no law that says that either. Each one got the whole benefit of the ads, if they were contributions. I will tell you, in my view, there is reasonable grounds to believe that they were not contributions because they functioned as an independent committee at the time of the runoff. That's based on our statutes. So I disagree with him on the assumption that these are contributions, but if he were really right that they were contributions, then they blew it. Then they exceeded the limit. There's no way around that. It's black and white. They did it. And they stipulated to that amount. I can tell you that, our goal in cases like this isn't just to take the easy win. We're trying to get to the right result. And we think the right result, in fact, in this case, is not that they were contributions, even though it's obvious they would lose if they were. The right result is, in fact, they did function as an independent committee. This commission has found on a binding advisory opinion to it, regardless of their view of what an advisory opinion is. Statute says you make advisory opinions and we're bound by them, and you did. And that says you can be both. Even the same organization can be both. I won't quote that. In my view, the reasonable grounds exist that they did in fact function as an independent committee. As far as I'm concerned, if they really want to say there's a dispute, we could send it to OSA and let OSA decide which one it is, because I think there's reasonable grounds on either way. And I will lastly say, without belaboring this, but I do want to emphasize this, because Mr. Myers has again attacked my staff, our staff, claimed that they acted unprofessionally, or that I acted unprofessionally. I have the emails here that show what actually happened. For example, and I won't go into them, but this is an email sent last night at 4:26. We will stipulate nothing. And we asked him to stipulate the numbers right there. We will not stipulate it. He stipulated it today. We sent him multiple consent orders. We asked for consent on these. I asked to negotiate these. I'll go down, talk about them with you. Said he will not talk. Sent me a proposed consent order and said he would not negotiate it. That's the bottom line. When someone says that to me and they say they're going to go to the state bar against my staff and try to do all sorts of things, or says that, you know, my job's in jeopardy, which all happened, then negotiations end. And that's where we are today. Thank you.
I'd like to respond, please, ma'am.
Okay, you can respond, but I would like to stay on the merits of this case. So you may respond.
Okay. We got an affidavit from Joanne Thomas Brown at like 9:30 last night. I mean, this is the sandbagging that happened the first time we complained about. So yeah, I wasn't exactly happy to try to stipulate anything. Of course, I hadn't found what I think is the magic bullet statute at that point either, because I just didn't know what they were up to, and I just have had bad dealings. The idea that we have recently talked about the state bar with he or Bethany or any of them recently is a fantasy. We have talked about it earlier, and that option is wide open. Okay. Yeah, and the idea that there were multiple consent orders sent to us. Do y'all want to sit? I mean, I gave you the highlights of what he proposed after Mr. Cathy so graciously said, you know, this thing can have, you can have a cathartic effect with these things, and y'all need to sit down and talk about this. Why in the world would I say that I've broken 2 laws and pay $6,000 when I've already been through the ringer up here once, and y'all have said the net effect was no probable cause? Look, again, you know, I hope you will look hard and think hard about this constitutional issue, because I think there's meat on the bone. I do not want to be the guy that, you know, is the fly in the ointment forever and ever. I think we make and work out our differences with an apology to Mr. Thomas about his financial records, and we can sing Kumbaya and you know, be done with it. Because I've got bigger fish to fry. I didn't ask for this, but I have been fined, as I said on that thing. I mean, now I'm probably at $60,000 in longer time, and this has got to end. And with that, I'll appreciate your time.
Okay, Commissioner Evans has something.
And I'll make a comment. Mr. Myers, I think we all appreciate you coming out today. I think you presented some good arguments, but I think at the end of the day, it's important to remember that, you know, this is the equivalent of a grand jury hearing, and the question that's before us is there reasonable grounds to believe that a violation of the Campaign Finance Act occurred? And based upon what I've seen, I would have to say, and I'm not saying you're a PAC, I'm not saying there's independent expenditures, but my instinct is there's enough to say that reasonable grounds do exist. And again, then there'll be an OSHA hearing. At that point, you can present the arguments, you can put forth further evidence, testimony, but it's my position right now that reasonable grounds do exist. And I think I also agree that it's best for everyone involved to keep pushing this along. So given that, I'll make a motion that reasonable grounds do exist for a violation of the Campaign Finance Act.
Okay. Well, there's a motion on the floor, so.
I'll second the motion.
Okay. Is there any discussion among the commissioners?
Mr. Myers, what did you consider yourself?
A PAC.
You did consider yourself a PAC?
Absolutely. But, and that's all we ever were, and all we will ever be.
We had numerous discussions about this over a period of months because I wasn't clear on how a PAC works. I'm not a political consultant and I'm not an attorney. So every time I say, well, Frank, what about this, what about, and he would explain it to me, and I understood, and I always felt that we were a PAC. There was never any question in my mind. And until we had a complaint, I didn't even know that such a thing as an independent committee existed.
All right, Mr. Ritter.
Yes, I I think we all agree that they consider themselves to be a PAC. If they're a PAC, and the PAC, whether they're a PAC or not isn't determined by what they thought, but how they acted. That's statute. If they were a PAC, then they would have violated the contribution limits. I think the facts show that whether they call themselves a PAC or not, they acted as an independent committee. Thank you.
Okay, so we've got a motion and a second.
Wait,
So
just writing
it's-
down, Tim, can I ask, do you mind? I'd like to perfect the record.
you may go ahead, but we're gonna have to vote on this.
Sure, I understand. I see what's coming. I just want to ask one question, Mr. Evans, if you don't mind. You voted against last time. You changed your vote based on what has happened in this proceeding, right?
I object. I want to object from my place. That's an entirely inappropriate question.
That is not,
Yeah,
because
and-
this is the whole due process argument that's not going away.
Yeah, we have to, if we're gonna,
You don't have to
based on
answer.
Robert
I
Rules of
understand.
Order, the discussion is between all of us. So, Mr. Evans, or Commissioner Evans doesn't have to
I understand.
answer that question.
I just
Okay?
felt like I had to ask to try to perfect the record, because
So-
this is the second bite of the apple that I was complaining about.
Okay, so, we've got a motion, we've got a second, and let's take it to a vote. All in favor? Aye. All opposed? Aye. Okay, so we have 3-1. Motion carries.
Thank you.
Okay, so it is at this time 12:49. Do we have our lunch here? Okay, great. I thought that's what it was. Let's take a 15-minute lunch break. And I may take things out of order, actually, before we leave, before everyone leaves. We actually have at the bottom of our agenda an executive session to discuss pending litigation. I would,
You want money from me?
I think we should move that to our, to lunch. So that we, yes, do all week lunch. Okay, all right, so we're actually, so we need to then make a motion to go into somebody needs to make a motion to go into executive session.
So moved.
Okay, I'll second that. So we are in executive session to discuss pending litigation while we eat lunch. And we'll be in executive session until we make a motion to come back into regular session. 1:32 p.m. We need a motion to come out of executive session and go back into regular session.
Make some motion.
Okay, I'll second that motion. All in favor? Aye. Okay, and I also understand that Commissioner Evans is going to have to depart us at this moment, but we still have a quorum. So, thank you for joining us this morning.
Thank you.
Okay, so I'm sorry? Oh, yes. Okay, so we are now back in item number 7C, which is 2010-0017. However, before we get to that matter, Ms. Wetzel, I understand that you may have some preliminary hearings where some individuals are actually here and have been very patient. So I would like to go ahead and hear those matters since they are here, unless there's any objection from any other commissioners. Okay, hearing none, then, Ms. Wetzel, which matters do we have?
I have letter L, 2017-0176 PC, and then Robert has letter P, 2017-0181 PC, and those are the two respondents that are available.
What are their names?
Miss L is Benny Crane, and then P is Tori Tomlinson. And they both have the same, basically the same facts as well, and are part of the similar cases as far as that we're presenting today. So, Mr. Crane.
Okay, so we'll hear 2017-0176 PC in the matter of Benny D. Crane. And Mr. Crane, thank you for being so patient with us.
Oh, I had a new one. Or maybe I have an old one. I don't know. The one that's up there. Commissioners, this is case number 2017-0176BC in the matter of Benny D. Crane. I have Mr. Crane here today. I'm thankful that he came and that he got to witness some of the commission's business today and that he was. So just as some background as to the two cases that I'm going to present now and Robert will present later. The city of South Fulton recently had their first elections in 2017. It was a special election because they were just recently incorporated and they're a new city. As part of that, several of the local officials, I think they had 73 candidates for city council and for mayor. And as a result of the amount of candidates and of the special election, there were a lot of late filings. So the city of South Fulton reported all the late filings to us, and as a result, we sent certified notices to the candidates that had late filings, late campaign contribution disclosure reports. We sent those as prescribed by law, certified. We gave them 15 days before we escalated it to the late fee to $375. We gave them 45 days before it was the late fee was escalated to $1,375. After we still didn't hear from them, then we commenced complaints against the candidates that had not filed and had not remedied the late fee situation by filing the reports that were due and paying the late fees. So that's what's going to be here before you today. We actually have some other cases that'll be brought here before you today that the respondents are not here, but it's the same facts basically. Mr. Crane was a candidate for mayor. He was in the special election, and he also was in the special election runoff. He received the second most votes in the runoff, in the special election. As a result of him participating in those two elections, he was required to file a 15-day before special election campaign contribution disclosure report, and then he was also required to file a 6 days before the special election runoff report. Our records indicate that he did not file those. We sent a notice. The fees have went from $125 to $1,375. He has 2 late fees, so that total is $2,750. And then if there were any civil penalty amount added to that, that would increase the total. Mr. Crane wants to settle this case and wants to enter into a consent agreement. Just at this point, we could not reach an agreement as to the amount of money. And because these are a number of cases that are coming before you right now, we would also ask that make the determination whether the escalated late fee should be reduced in any amount due to hardship or for any matter, or they should remain at the escalated amount. So that's all I have to present right now. If you have any questions, please feel free to ask me, and Mr. Crane, I know, is willing to speak if you have any questions for him.
Okay, I'd like to hear from Mr. Crane.
Thank you, Madam Chair. It's my pleasure to be here, but I'm not here because of my lack of willingness to participate in the legal process. But it's just a statement of a failed campaign and a campaign team. I spent 10 years of my life advocating for and fighting for the creation of the new city of South Fulton. I almost single-handedly went before our state legislature to get the legislation, the enabling legislation passed. I went to the Georgia State Institute of Public Policy to get a feasibility study done. I signed my name on the dotted line. I raised the money to get it paid for. I'm an advocate for our community. I'm not a politician. I'm not a seasoned person who know how to run a campaign. And I made the horrible mistake of soliciting the help of someone that I thought knew what they were doing. And when I started this process, I created email accounts that bore my name. It was B. Crane. And I turned everything over to someone that I paid a healthy amount of money to take care of running the campaign, managing its affairs, and being in compliance with the law. I made two mistakes. One, I ran for public office. And number two, the person that I chose to take care of this work. I've now come to understand and talked to Ms. Wessel and the attorney that I consulted before I came here that several emails were sent. It wasn't until this process got spiraled out of control that I was able to finally find that person who represented the campaign and got control of the email address. And there I found several notices from the city that things had not been taken care of. And the certified notification that Ms. Wessel made reference to, I did not get those. And I take full responsibility because at the end of the day, I put my name on the ballot, so I take full responsibility. I just ask for your grace and mercy because it's not because I didn't want to take care of it. I would have willingly done it. That's why I was here early before, anyone else that was here, because I wanted to face the music because I'm an honorable, I'm a credible person. I want to do the right thing. But the amount that you're asking for is far surpassing my capacity to take care of it. Not just because it's Christmas, but because we just don't have those kind of resources. I want to face the music, but I certainly solicit your grace and your mercy to reduce those fees and fines, and I certainly want to do the right thing.
First, thank you for being here. I really appreciate that. I think there's a lot that can be garnered from candidates and former candidates when they come and kind of see how our process works. And I appreciate you working with staff. And thank you for all of your hard work as a citizen, too, of Georgia. The people of South Fulton are very lucky to have you, whether as their mayor or not.
I agree.
So, it sounds like what you're requesting, though, is a hardship waiver. And Ms. Wetzel, has he filed a hardship waiver?
No, he has not filed a hardship waiver because these are different in the aspect of that the late fees were escalated after notice had been sent, and they were escalated by statute, and complaints had been filed, and then there was recognition that, I owe these late fees, and in speaking with Mr. Ritter and Robert, we wanted to present it to y'all to, from one, say, yes, y'all can consider hardships when assessing these late fees for these cases where they've escalated due to statute, and also just to get an idea of where y'all felt, if you would consider hardship waivers.
Yes, Mr. Ritter.
Thank you, Madam Chair. Just very briefly on that. So in this and some other cases, what happened is that not only they had noticed, but it was only when we escalated them and they went forward and then they were to come here that they sought reconsideration of that matter. In fact, normally, even if we got just an escalation and someone said, wait, I had such and such, we would consider that as a hardship. But when it gets to actually being on your agenda, then we think it's probably past where we can consider the hardship ourselves unless you direct us to do so.
Okay.
Madam Chair.
Yes.
One thing is to say, certainly I did not respond because of some exorbitant fees that were being levied. I responded because I got this packet and I opened it and I responded to it. It wasn't for any other reason. Had it been for half the amount, I would still be here. So I'm not driven by the cost of being here. I'm asking for mercy because of its high cost. But I would have been here either way had I gotten this some long time ago. I responded to this like I would have responded to anything that I had gotten, but unfortunately, I failed to have control of an email that was used for the campaign's purpose, and now I have it. And, I wish I had handled my business differently, but I didn't know to handle it differently.
Okay. All right, thank you. Any thoughts from any of the other commissioners?
How far apart are we?
He's really close. I mean, it would be an I would accept what he is.
But you don't have the authority.
Well, because it's still less than the amount of the 2 escalated late fees is what he's offered. It's still, so the amount of the escalated late fees, no civil penalty, is $2,750, which is a lot of money. And what he's offered is really close, it is close to that. But because it's a late fee, it would be a waiver of the late fees, I didn't feel like, as far as in my position as the staff, that I have the authority to waive those late fees.
In your opinion, is this a genuine economic hardship?
I think so.
I don't even need to go behind that if you, in your staff ability, tells me you think this is a genuine
Oh, I do.
hardship, Mr. Cheek.
I would agree. So is that a motion that I'm hearing from you, Commissioner Cap?
And we could reduce it to the initial late fee level of $125 for each one,
Which, how many?
2, so that'd be $250.
I'm good, yes, sir.
All right, I move that the fees be assessed in the amount of $250
I'll second.
for all past
Yes.
fines.
Okay. Thank you.
We have to vote. We have to vote. I seconded, so now we have to vote. Okay, all in favor? Aye.
And thank you for laboring in the vineyards of politics to get you a city down there. So,
It's
good
my
job.
pleasure, sir. And I'm not glad to be able to serve.
You know, it was rewarding for you to have that done.
It was one of the biggest things I've ever done in my life, you know, standing up a great new city, which happens to be the fourth largest city in the state of Georgia, sixth largest city in the state, and the third largest city in Fulton County, so it was no small matter. It was a big deal.
Going back down there and keep doing the Lord's work.
Thank you, sir, appreciate it.
Renaissance now?
Yeah, Renaissance now. They voted last night.
They voted last night about Renaissance, and it's a huge stink, because many of the citizens don't want to have it renamed as Renaissance rather than the city of South Fulton. And the commission voted to do it anyway, so, but the mayor is not, the mayor says it's going to be, we'll see.
All right.
They want us, I'm sure.
Okay, now I understand from Mr. Lane that Mr. Tomlinson is here. Is that correct? Okay. All right, Mr. Tomlinson, go ahead and come forward, please, sir. We're going to hear the matter now, 2017-0181 PC in the matter of Tory Tomlinson.
Good, sir, how are you?
Were you at this meeting last night? Were you at this meeting last night?
No, I was at the first one, but I didn't go to the last one.
Commissioners, without falling too much of the same ground that Ms. Metzler went over, Mr. Tomlinson qualified to run as a council member for the city of South Fulton. I believe, if I remember correctly, he was unsuccessful since he did stand for the election in the special election held in March of 2016. He was required to file a March 6, 2017 campaign contribution disclosure report. That report was not filed. Mr. Tomlinson received on or about May 4, 2017, notice from our office via certified mail that he had outstanding reports. That notice resulted in escalation of the late fees to $1,375. I believe I sent additional notice to Mr. Tomlinson with the complaint. That was served by UPS overnight mail, and that was served on the date on or about November 9th. So I believe you received it on the 10th of November, thereabouts.
It's a good day, November 9th. It's my birthday. I'll accept late friend. Just kidding, just kidding, just kidding.
Contained within that complaint, of course, we had our evidence, and I did have a proposed consent order for Mr. Tomlinson, but this is the first time I met Mr. Tomlinson. So we've not engaged in negotiations as Ms. Watson had done with her previous case.
Okay, all right, Mr. Tomlinson, would love to hear from you. Thank you for being here, by the way.
Thank you.
And for your patience.
Thanks. Well, yes, this was my first time. I'm very well known in my community for doing a lot of charity work and working with kids, and I was the community favorite. So this was my first year, and with us being a new city, I stepped out on a limb and trying to be councilman for my district. So it was a learning process for me. This whole ball game was a new ball game for me as well. The letter that I received on November 10th, yes, it was scary and it was all new to me because knowing that I could have paid a $125 fine versus a $1,700 late fee, I would have definitely paid that without any problem. I didn't even raise, I brought my GoFundMe account here with me where I just raised $1,300, and here it is, I'm here today paying a fine that's more than the money that I raised for my campaign. So, I just want to say that if you could, you know, do what you could for me. I apologize, and I accept my fault as a man, you know, for not taking that part seriously. I had a campaign manager as well who left me out halfway through the campaign. Also, when I first went to qualify, I was asked, was I going to raise more than $2,500? And I should have signed a sheet of paper. But at that moment in time, I was hoping that I did raise more than $2,500. So I didn't sign that paperwork right then because that was just a question that I couldn't answer at the moment. So that's another reason why I have myself in this situation.
This report was due when?
March 6th, 2017. And remember, you have a December report due too. December 31, 2017.
Right now?
In a few weeks, yeah. Just free advice.
Or file that waiver,
Yeah.
or file the affidavit.
Yeah.
We'll talk to you.
Yeah.
So, you and Mr. Lane, I understand, have not had an opportunity to discuss this case, and I know that staff was very busy in the first half of this meeting. I would be okay if they had some time out in the hall to see if they could negotiate.
Would you be in the same place, though, that Ms. Wetzel was, where you didn't feel like you would have the authority to waive it to a point?
I guess one thing I'd like clarity from the commission on is that one reason that we are filing these suits is because these individuals, and I'm not speaking on Mr. Tomlinson, I'm picking on everybody that we're doing this to, because you're going to get a lot of these cases where people have received notice of the we don't file complaints until after 90 days have come and gone, so people have the opportunity to file and pay, reach out to us, say, hey, you know, this is a hardship, I can't do it, but I'll file. I mean, and then what's happening is people are becoming motivated on the back end. So my question is, how lenient do you want us to be? For example, like I understand showing leniency to the individuals who showed up today, they're showing concern, they're actually showing up. But let's say for the people who aren't showing up, because you got like another 10 that just didn't show up today, are we going to show them leniency as well of somewhere amount, or are we going to impose the escalated late fee because they have completely ignored it? And like I said, I'm not picking on Mr. Tomlinson, because he's here. But that's more of my concern, just so I know better how to negotiate with individuals. Just kind of guidance.
I'm going to give you a response that I know that you're not going to like, at least from me, that won't be from the commission as a whole. But, you know, I think to an extent it's got to be a case-by-case basis. And the reason being, the prior case that we just had, I heard a fairly legitimate reason as to why he didn't get the initial notice, of the late fee.
I completely understand, and this might be a solution the commission might want to entertain instead of us going into the hallway and negotiating. Y'all have the ability to find reasonable grounds, and that doesn't mean he's guilty. And there's an automatic stay that goes into place where Mr. Tomlinson and I can negotiate, and we can try and resolve the matter. And if we are unable to, then it can proceed forward. Now, I'm not going to be a jerk. I try not to be, unless someone tells me to go somewhere.
Well, you heard some precedent just a few seconds ago.
Yeah, it is.
Right, and while I think we're all aware of that 30-day stay, Mr. Tomlinson is here, and I think my direction would be for you guys to go out in the hall and see what you can negotiate.
And as you say, you're not a jerk, don't take over a minute.
Can I say one thing?
Sure.
The certified letter is definitely the reason why I was here, so I don't know the situation for the other candidates, but that's one letter that I received and I read and took serious when I got it. All of the other ones, whether they were emailed, another thing, I had a Vote for Tory email during my campaign, and like after the election was over with, that's just an email that I didn't have time to check or receive, so if anything was sent to me at that email, no, I did not get it, because I had moved on with my life. So I just wanted to say those two things.
And just for clarification for the commission, we don't send any of these notices by email because statutorily it means nothing. It all comes by certified mail or statutory overnight delivery by UPS.
Okay. I think you guys should go chat in the hallway, and we'll move forward with the agenda when you're done. Come on back in here. Is anyone else here for a preliminary hearing?
Yeah.
No, for disclosure to the commission, Mr. Kenton Wainwright, who was, it is number 9, or number N, letter N, letter N. Mr. Wainwright was here, but unfortunately he had to leave. He had to report to work. He felt that he needed to go, so he wouldn't have an issue. But he is looking forward to negotiating. He understands that we're proceeding forward, and he understands the automatic stay and so.
Okay, all right, thank you for that. Okay. Oh, I've already thank you. Okay, so let's then move on to 2010-0017, that's letter C, in the matter of Joseph Macon, and that is Ms. Wetzel's case.
Correct. Commissioners, this is a very old case, and the reason why it's just coming before you now is because we had a very difficult time locating Mr. Macon, and also to the point of I had to contact him on LinkedIn to get to try to get him here today, but he did not show up. Mr. Macon was the former mayor of East Point. As mayor, he had several disclosures he was required to file. One, again, this is a late fee case. He filed the report late, and he had a late fee of $125. He's paid that late fee. The agreement that I had presented to him to resolve this case was simply for him just to sign a compliance order with no civil penalty because it's an old case. The evidence is pretty old, and he had already paid the late fee that would have been associated with the violation that was substantiated. However, he has failed to return the compliance order to me. I'm hoping that if you find reasonable grounds to believe that a violation occurred, that maybe correspondence from Mr. Fuller would encourage him to engage in corresponding with us. We've left several telephone messages. Like I said, we've sent messages on LinkedIn, we've sent email messages, have heard nothing from him. But to be able to resolve this case, there has to be some kind of closing documentation. And what I had proposed initially was just a compliance order. But again, he has not agreed to that or signed that. So I'm asking today that you find that there's reasonable grounds to believe that he violated the Campaign Finance Act by filing a campaign contribution disclosure late.
Okay. All right, any questions from anybody? All right, any motions?
I move with my problems.
Okay, I'll second that. All right, all in favor? Aye. Okay, moving on to item D, which is 2015-0065 and 2016-0009 in the matter of Jefferson Clark. And I believe, Ms. Wetzel, that is your case as well, too.
It is. Both complaints against Jefferson Clark were filed by Griffin Watson. Jefferson Clark was a former member of the Darien City Council of McIntosh County. The first complaint, it was alleged that he failed to disclose some items on his campaign contribution disclosure report. And then the second complaint alleged that, again, that he failed to disclose some items on his campaign contribution disclosure reports and that he failed to file campaign contribution disclosure reports in 2011. The allegations that he failed to file 3 campaign contribution disclosure reports in 2011 were substantiated. He did file those late. However, I mentioned earlier in the meeting about there being a commission order in April of 2012 that only 1 late fee stands for that period of time. So there's only 1 outstanding late fee for that matter. And then the second allegation was that he failed to disclose attorney's fees incurred in relation to his campaign. There was a recount effort in Darien, and he was the losing council member, and he filed a lawsuit in regard to that and hired counsel to redo the election, basically, and they did. And he failed to disclose any of those amounts on any campaign contribution disclosure report. So he has a violation for failing to file a campaign contribution disclosure report, and then he also has a violation for failing to disclose the amount of the attorney's fees that were incurred in relation to his campaign. And I have not heard from him. We sent him notice. Oh, and additionally, he has an outstanding late fee for filing a personal financial disclosure statement late. So he has 3 violations. That he untimely filed a September 30th election year CCDR. He untimely filed a personal financial disclosure statement in 2011, and that he also, in 2016, 2015, he failed to disclose expenditures made for attorney's fees incurred when he contested the results of his election. So I'd ask that you find reasonable grounds to believe that these 3 violations occurred and to forward it to the Attorney General's office.
Okay. All right, any questions for Ms. Wetzel? Okay, I'll move then that we find that reasonable grounds exist that Jefferson Clark violated the Campaign Finance Act. Do I have a second? Okay, all in favor? Aye. Okay, I see Mr. Tomlinson back in, as well as Mr. Lane. Let's go ahead and finish that matter back up. So we're going to take back up 2017-0181 PC.
Commissioners, in the desire to be expedient, Mr. Tomlinson has agreed to pay a $125 late fee, file his report within 30 days from the date of the order signed by the commission, and he now knows he's got to file his September 31 report. So I think that takes care of it.
Okay, so then that moves to a consent order, correct? Okay. All right, so then we need to vote on it then as a consent order, correct? Okay,
I move that we accept that consent order.
I'll second. All in favor?
Aye.
Aye. All right, fantastic. Thank you for your patience with us today.
Thank you,
Thank you for coming.
Thank you. Okay, moving on now to 2016-0011 in the matter of William Bill Johnson. It's tab F. And I believe that's Mr. Lane's case.
It is. Commissioners, Mr. William Johnson's case Mr. Johnson's case began on or about February 10th when Mr. Griffin Watson, this is kind of a fun case, they're both from the city of Darien, they're both on city council. Mr. Johnson filed a complaint against Mr. Watson, and Mr. Watson filed a complaint against Mr. Johnson. They both had similar violations of the Campaign Finance Act. The other gentleman has since settled. But for Mr. Johnson, he qualified to run for city council in 2013 and 2015. Based on those qualifications, he had a number of reports that he had to file with us. The ones that he missed and did not file was his personal financial disclosure statement for calendar year 2011, and then his campaign contribution disclosure report for December 31st of 2012 and 2013, and then the 15-day report before a special election. He has now since said he's been cured of seeking higher office. He's ready just to hit it. We have had extensive discussions about settling his case. I think we may have reached an agreement, but he has yet to return the settlement offer to me, and I have not heard from him since last week. So we don't have a settlement. He has not raised any defenses that, for example, that he didn't qualify, he didn't run. The only defense that he has raised is that he maintains that the city of Darien cannot find his records. As I've explained to him, they can't find his records because he didn't file his records. Every other official for that period of time, they have the records, they've transmitted them to us. They can't produce that which they don't have, and that's what we alleged he's failed to file. He has no copies of them, so with that in mind, I'd ask the Commission to find reasonable grounds to believe a violation of the act had occurred, refer the case for further prosecution. If you'd like to enter into that consent order, I'm happy to accept it. Continue negotiating, we can bring it back to y'all in March. But if he's just playing for more time, then.
When did he get it?
The consent order?
Yeah.
About 2 months ago.
You just want to wait on him a while?
I prefer not to, because a lot of these individuals, and I don't mean this disrespectfully to a lot of individuals we deal with, a lot of people play for more time. We get a lot of, I didn't receive that. I kind of call it the dog ate my homework excuses. Sometimes you have to move forward to kind of light a fire for someone to do what they need to do. It's kind of like what you're seeing with the late fee collections today. For example, Mr. Tomlinson, and I'm not trying to pick on him. I did not hear from him at all, and that was after 6 months of tracking him down and serving him multiple notices. So, nothing bad happens to him with the finding of probable cause. And I'm not gonna like jack up his fine because you found probable cause.
Well, and you still have 30 days to resolve it.
And truth be told, even if it goes beyond 30 days, because I know Mr. Fuller's got plenty of work to do, that he's not going to draft it on day 31, I'll take a settlement agreement 60, 90 days, as long as Mr. Fuller's not waiting for the decision from OSA. Yeah, sure. Let's negotiate that.
Okay, all right, any other questions? All right. All right, then I will move that we find reasonable grounds to believe that William Bill Johnson violated the Campaign Finance Act. Do I have a second?
Second.
Okay, all in favor? Aye. Okay. It appears that we are on letter G now, and that is 2016-0035 in the matter of Robert Christopher Phelps.
Commissioners, Mr. Phelps is a sitting Superior Court judge in Elbert County. He sent in a request for a continuance. He has 2 specially set matters for today. I did not see grounds to object, because I know that's like herding a bunch of sick cats. So I think a continuance should be granted. I may have overstepped a little bit. I told him not to cancel his specially sets. He needed to go do those, and I would kind of not object. So.
Is it in here? I don't have his request.
Judge Phipps.
He sent a very, it's not a motion that you would think of normally.
What's he done on?
Oh, Lord. He failed to file a March 31st, 2016 campaign contribution disclosure report. He has subsequently filed it. His request for continuance, as I'm being polite and calling it that, came in a very long nastygram that we received. I don't know exactly how much detail y'all want in it.
You call it nasty, right?
Yes, sir, I'm trying to be polite.
I sent a letter that was objectionable.
Yes, it was. It was strongly worded.
May I see?
Sure. Sorry.
I'd like to read it as well.
Here we go.
Another copy.
Yeah. Commissioner, would you like one as well? Sorry. I'm going to go to Bethany so we don't all get a hernia.
so he's asked for continuance. Requested it 10 days ago. And by your statement, you also told him not to cancel court. So, I'm inclined to continue it. Anyone disagree?
No, I don't.
Okay, all right. I'll make a motion then that we continue to our next regularly scheduled.
What did he do wrong? I can't.
What happened is he didn't file his report. And I've given him, in response to his letter, which was it was strongly worded, but it was nice and respectful for a spiritual judge, because you generally don't use those enemies. I explained to him how the law was violated. He didn't file the report. I know he keeps saying, well, I filed it later. You filed it after you got a complaint. You filed it after we began the case. That doesn't count. And we explained to him, you know, it's still a violation. We're not saying you're a bad person. We're not saying you're a bad politician or crooked or anything else. It's a regulatory action. We filed it. There's a civil penalty and a late fee that goes along with it. I've invited him when he has time to.
But the mailing he did was still not timely. He didn't file anything.
No, sir, and also the way the law is written, it's state level officials, superior court judges shall file electronically. We're not permitted to take paper filings. In fact, his paper filings are returned back with a, sorry, we can't take this, please file. And I explained to him at great length that the reason for that is because if you send us the paper filing, our system is not configured where it can be entered into a computer system, and the general public cannot access it unless they know for a fact we have it filed and they contact us to produce it pursuant to the open records. So that's why it's a shall file electronically. You know, I'm hoping he finds my correspondence to be conciliatory. I've invited him to, when he has a free moment, let's talk about it, let's discuss it. We're not that bad.
Okay. All right, so I've made a motion then that we continue it to our next regularly scheduled commission meeting. Do I have a second?
Second.
Okay, all in favor? Aye. Any opposed? Okay, all right, it goes on to the next calendar. All right, we now move to letter H, which is 2016-0037 in the matter of Chandon M. Adams, no relation that I'm aware of, and that's Robert's case.
Yes, ma'am. Commissioners, Mr. Adams qualified to stand for election as the District 5 Commissioner for Forsyth County in 2017. He actually filed his declaration of intention on March 22nd, 2016. As such, he was to file under the election year schedule 21534C2, and he missed his his September 25th report, his October 25th report, and his December 31st, 2016 reports. Unfortunately, I've not heard back from him. He filed up until the point where he lost in the primary. Most people don't realize that the way the Campaign Finance Act is written, when you qualify and you run in the election year, you file a report even after you lose, just like you had won. So unfortunately, he missed those 3 filings, and that's the extent of the case. I'd ask that you find reasonable grounds to believe that the Campaign Finance Act is violated.
Okay, any questions for Mr. Lane? Okay, then I'll make a motion that reasonable grounds exist that Chandon Adams has violated the Campaign Finance Act. Do I have a second?
Second.
Okay, all in favor? Aye. All right, moving on to 2017-0189 in the matter of Joe H. Brown Jr., Mr. Lane.
Commissioners, Mr. Brown. Mr. Brown is the District 3 Commissioner for Butts County, Georgia. He's currently the incumbent. He most recently filed his declaration of intent to accept campaign contributions on March 3rd, 2014, and he was qualified to run in his most recent election, which was 2016. He failed to file his personal financial disclosure statement for calendar year 2016. This is not something that we find that is uncommon with local officials. Local officials will sign what's known as an affidavit of intent not to exceed $2,500. That relieves them of filing periodic campaign contribution disclosure reports. It does not relieve them of filing the personal financial disclosure statements. And that tends to be an issue we tend to have where people say, I didn't know you need reports. No, you owed us one. That one's not relieved, and that's just the case he has. I've reached out to him a number of times. I've not heard back. So I'm afraid that's where we have it. I asked the commission to find reasonable grounds to believe that the Campaign Finance Act has been violated.
Okay, any questions for Mr. Lane? All right. Okay, then I'll make a motion that Joe H. Brown Jr., that reasonable grounds exist, that he has violated the Campaign Finance Act. Do I have a second?
Second.
Okay, all in favor? Aye. Okay, any opposed? Doesn't appear so. Okay, moving on to letter J. In the matter of Robert Louis Henderson Sr., 2017-0197.
Mr. Henderson's also Commissioner in Butts County. He's just District 2. There's a gentleman by the name of David Massey who's obviously mad at the commission. He's filed on every member of the commission. Mr. Henderson filed his declaration of intent back in September 22nd, 2010. He's been an incumbent since that time. He failed to file his June 30th, 2017 campaign contribution disclosure report and his calendar year 2016 personal financial disclosure statement. And Mr. Henderson did mail in a payment for his $250 in late fees the other day. And I spoke with him by phone and was interested, he was interested in the consent order that we sent to him, which had reasonable terms. His response to me was, this fill-in of slur will not be coming to Atlanta. And I said, okay. So I'm taking that as a no to the consent order. He said, no, you can send it to me again and I'll sign it, but I'm not coming to Atlanta. So it's a very interesting.
Where is he?
Butts County. So I didn't quite know how to take it. So I've mailed him another consent order. Maybe it'll come back, maybe it won't. But based on his statement that he's not coming to Atlanta and we can't make him, we might as well just go ahead and lock him up. That's the quote. I'm asking the commission to find reasonable grounds for the Campaign Finance Act is violated.
Okay. All right, any questions for Mr. Lane? Okay. All right, then I'll make a motion that reasonable grounds exist to believe that Robert Louis Henderson Sr. has violated the Campaign Finance Act. Do I have a second?
Second.
Okay, all in favor? Aye. Okay, moving on then to 2017-0183 PC in the matter of Shannon Eugene Jones. I believe that is Mr. Lane's case as well.
It is, Commissioners, and this is another City of South Fulton case in which Mr. Jones qualified to run for the District 3 Council seat. Mr. Jones failed to file the March 6, 2017 special election campaign contribution disclosure report. He was notified on October 6th and November 9th of his outstanding report and late fees. No correspondence has ever come back, no filings have been made. He was actually served this complaint and notice of this hearing by statutory overnight delivery because he started to no longer accept his certified mailing from us, so we had to escalate it up to UPS service.
He did file, right? He was just late. I thought this says he filed on March 14th. Or am I reading this wrong?
Forgive me, Commissioners, I don't have the actual report in front of me. If it's in the investigative report that says he filed late, then he filed late.
Okay.
He's just not paid us.
That's what I see as well too. He filed, he was just late.
He did.
My report is right, my memory's bad.
Okay. Okay, any other questions for Mr. Lane? Okay, then do I have any motions? I'll move that reasonable grounds exist to find that Shannon Eugene Jones has violated the Campaign Finance Act. Do I have a second?
Second.
All right, all in favor? Aye.
Aye.
Any opposed? Okay. It appears now that we move on to letter M, which is 2017-0178, in the matter of William Irvin Brezel, I'm mispronouncing that. That is Ms. Wetzel's case.
Chair, may I stay in my place?
Sure. Hang on, let me turn your microphone on. What number are you?
12.
Okay. Okay, there you go, Ms. Wetzel.
Commissioners, this is another collections case for this city of South Fulton, excuse me. Mr. Brazile was a candidate for South Fulton City Council. He filed a declaration of intent to accept campaign contributions on January 9th, 2017. He was only in the special election, so he was only required to file a campaign contribution disclosure report 15 days before the special election. A notice of the late fees was sent to him on May 4th, 2017. 90 days had passed, and so the late fees were escalated, and we have not, and then a complaint was initiated. We have not heard from Mr. Brazile, and we ask that you would find that there are reasonable grounds to believe that he violated the Campaign Finance Act and that he failed to file a special election campaign contribution disclosure report.
Okay. All right. Any questions for Ms. Wetzel?
What were his fees escalated to?
So $1,375. He never filed, so it didn't stay at the 125 level.
You know, the only one that stayed at the 125 level was the last case, and you didn't.
It didn't show. Well, and I have a gentleman in the consent portion that did, who was a South Fulton person, but that was it's random.
Okay. All right. Any other questions for Ms. Wetzel? Okay. All right. All right. I will make a motion then that reasonable grounds exist to believe that William Irvin Brezel violated the Campaign Finance Act. Do I have a second?
Second.
All in favor? Aye. Any opposed? Okay, all right, now we have, moving on to 2017-0177 PC in the matter of Kenton Wainwright. That is Mr. Lane's case.
Mr. Wainwright also qualified to run for the city of South Fulton special election, except he's running to become mayor. He qualified on January 13th, 2017, and also filed his declaration of intent. He failed to file his March 6, 2017 special election report. It's still outstanding. He has yet to file it. I've met with him a number of times. I often explain that he's got an emergency, he's got family issues, he's going to get around to it. I give him credit for showing up.
Well, and he came today,
He did come
correct?
today, but it was more of the same. I'm going to get to it. Today, we've yet to have a filing. We haven't made it. I recommend the commission find reasonable grounds to believe the Campaign Finance Act has been violated. He's also coming by next Monday too to talk some more.
Okay, any questions for Mr. Lane? All right, then I'll make a motion that reasonable grounds exist to believe that Kenton Wainwright violated the Campaign Finance Act. Do I have a second?
Second.
Okay, all in favor? Aye. Okay, it appears that the matter of Ms. Bankston is a consent order now, correct?
That's correct.
Okay. All right. All right, then let's move on to 2016-0031 in the matter of James C. Lowe, and that is yours, Mr. Lane.
Yes, Commissioners, I'm going to move for an continuance on the grounds that Mr. Lowe did not receive proper service of today's hearing. The notice that we sent out to him came back last week and is undeliverable, unclaimed. So I don't think it'd be appropriate to go forward without further notice to him.
Okay. So you're making a motion for continuance based on lack of service at this point?
Yes, ma'am.
Okay. All right, any questions for Mr. Lane? All right, I'll make a motion that we grant the continuance. Do I have a second?
Second.
Okay, all in favor? Aye. Any opposed? Okay, it also looks like 2017-0184 PC in the matter of Khalid Camus is now preliminary hearing, is that correct?
Correct.
Okay, all right, that is actually under consent orders item 9, but is D now.
It was moved from the.
You moved that
Yeah,
from
it's
the
to
consent order,
consent,
so.
no, it's moved to the consent orders.
Right, the system
Okay,
Yeah,
oh,
it's
the note
confusing.
says that it's moved, okay,
moved from.
moved from, okay, it is actually a consent order.
I'm sorry.
Okay, all right, it's all right. Okay, so now then, let's go back, and the items that are in preliminary hearings that are consent orders that we've not taken up, let's take those up. Because all we need to do is vote on those, correct? Okay, and Stefan, do we need to vote on those individually? We do, right?
I will tell you that it has been the fact that they have voted on them collectively in the past, and no one has ever challenged that. So I can't tell you that I think you need to vote on them individually, because I think you can vote on them collectively. It just depends on how much you want to hear, but the reality is that if you've already reviewed all the consent orders that came in the materials, and you wish to at least tender a motion to approve them all, I don't think there's anything wrong with that.
Okay, all right. Gentlemen, any thoughts?
My thoughts are let's do them all collectively,
Okay.
since we have the material.
And that's fine, they're the same as what we've already done.
Correct, yes.
Okay, then I make a motion that we approve all of the matters that are now consent orders, that we approve them collectively. Do I have a second?
Second.
Okay, all in favor? Aye. Okay, and for the record, do I need to read those out?
If we could,
I
let's
think
just
we
read them.
probably
Yes.
should. Okay, so the first one is, that we have approved as a consent order is 2014-0027 in the matter of David C. Simmons. The next one is 2017-0190 in the matter of Kevin Rivers. The next one is 2017-0179 PC in the matter of Angelique Gay Bankston. We then have 2017-0185 PC in the matter of Carrie Peters Reed. Then we have 2012-0046 in the matter of Melissa Watson Morrison. 2013-0053 in the matter of Norman Garrett. And then 2017-0184 PC in the matter of Khalid Camus. And those are all the consent orders that have been approved by the commission. Okay, now, we have already had lunch, and we have already gone into executive session as well. So at this point, we are on item number 10, which is a report of the executive secretary. Mr. Ritter.
In the matter of time, I'm going to move through this very quickly. Please don't hesitate to ask me questions as appropriate. First of all, on our administrative dismissals, the authority to administratively dismiss cases that have no merit whatsoever factually, or they have no jurisdiction in the commission, has been granted to the executive secretary. There's only one case that was dismissed. We always report on these just as a matter of courtesy so that people know what they are. This is a matter of 2017-0171 in the matter of Timothy Becker. The complaint accused him of being an independent committee, which he was not, per se, based on his conduct. Therefore, he was not prosecutable at all as an independent committee, and it was appropriately dismissed on that basis. And that's the only administrative dismissal. Let me then move on to the issue of waivers and backlog and so forth. We had 49 waivers that were denied and 35 waivers that were granted through since the last meeting. 5 in addition were partially granted. At the moment, we have 24 additional waiver requests that are pending. And again, we follow the criteria of the commission and our announced criteria, and looking at those waivers, they're all listed for hardship. So you've considered those today. And as an indication, does add up to a lot of money. That's $470,600 in fees that are waived. Those are late fees, and all of those were shown to be hardship. I should emphasize many of those sound very high because of the escalation of the late fees. But again, those are the numbers on those. As far as our case stats and backlog and so forth, we only have one case that is old that still remains, and that's the Oxendine case, 2009-0007. We currently have 102 active cases, which includes 27 cases that are in APA prosecution through the Attorney General's office. We have 154 audits that have been completed or in process. A number are going into more in depth. I will also say, as I've said at prior meetings, but this has also been something that the press has been interested in, and I think properly so. As an audit practice, rather than just randomly auditing all the time, we do occasionally do random audits. The major elections are the ones that really need the attention. They're the ones that draw the complaints, and we want to handle everything in a nonpartisan and non-biased manner. So our practice for major elections, such as governor, lieutenant governor, and so forth, will be to do audits on all of the candidates in those elections. Of course, those audits really can't be completed until the election is over, because they have reports that aren't due until the end of the election, but we're conducting those audits. There has been some press on one of the candidates, but that was absolutely routine. And in fact, there are potential findings against a number of city of Atlanta candidates that will come out as we continue to complete those audits. But we think that's the best way and the fairest way to do those audits. And we have audits that we do for many things, but that's the newest, I think the biggest one that will be the most active. We have currently on collection cases, 13 cases for collections, 7 of which are in active repayment. So the other 6 are ones that are having either service contact issues or refusing repayment. But we have 13 total collection cases going on right now. As far as our office goes, we have 3 new employees. And ladies, can I ask you to stand over there? Or I'll hide behind the pillar over there. I just like to they invited them to have a chance to come to the meet. Oh, there's Rochelle over there. There's Rochelle, Lakeisha, and Marie. And they are all,
Thank you.
yeah, they were delighted to have them. They are working under Maria, and that is doing data entry and catching up on a variety of other things. And so great to have them. We are currently in the advertisement collection of resume process for an additional IT person. That should be completed next week. I've already got some proposals. I will say that it's not as great as I'd like, but maybe we need to pay more. But you know, we get what we get. So that's what we are. I will, again, finally like to compliment our employees for the excellent job that they are doing. I think you do have a great staff. I had mentioned, I think the Department of Audits and Accounts will have a performance audit update soon. We're looking at a draft of that, and I will discuss our response with the chair with that before I respond to that. Okay? And anybody else, Jamie or Dennis, if you want to talk to me about that, I welcome your thoughts. I can tell you that we are going to handle this in a professional manner as possible. Okay, and appropriate. So thank you.
Okay, thank you, Mr. Ritter. And welcome aboard to the new employees.
Thank you.
Thank you. Okay, and now, Mr. Fuller, item 11, Attorney General's update on cases in your office.
Number 16.
Yep, I got you.
Okay.
You should be on.
Okay. The only one update I have involves a case that I reported on at last meeting. That's a matter of Christopher G. Nicholson. We were scheduled to have a OSA APA hearing tomorrow, actually out in Augusta. I was contacted by Mr. Nicholson on Monday of this week that I had agreed to settle the case and sign a consent agreement. So it should be in the mail. So we've put on hold the APA hearing, which, just as a quick refresher, he had a lot of sort of registration snafus of failing to file personal financial disclosure statements, failing to disclose certain items in that report, failing to file a certificate of intent to raise money, and then I think he had a late campaign contribution disclosure report. So low-hanging fruit, but nonetheless, something worthy of an APA hearing. But that should be settling, and hopefully that consent order will be brought before you next meeting.
All right. Any questions for Mr. Fuller? Okay. All right. Already on item 12. Item 13, any public comments from anyone? Nothing from Mr. Chalmers?
No, ma'am.
Okay. All right. Anyone else? Okay. All right. So I'll make a motion then that we adjourn our December 13th, 2017 regular meeting at 2:38 p.m. Do I have a second?
Oh, I so would like to be second.
All right. All in favor? Aye. All right. Thank you, everyone.